Uh, Morning. This is a brief opening to the Wellington Proposed District Plan uh, Stream 6. We have a technical difficulty at our hearing base where the floor is closed off. So we're going to have to be live for about 30 seconds and then adjourn until we have proper public access to the hearing for anybody who wants to attend. So we'll be back online as soon as we've sorted it out at the venue. So this is the belated resumption of the Wellington PDP Stream 6 hearing. I'm Trevor Robinson, the chair. I'm accompanied by Commissioners McMahon, Burge and Schofield. We have two reporting officers with us, Jeffries and Ms. Van Schuren Giles. I think we're going to start with the correction zone, Mr. Jeffries.
That's right.
How would you like to proceed? Over to you.
Morning, Commissioners. My name's Joe Jeffries. I'm a Principal Planner at Wellington City Council and the Reporting Officer on the airport and correction zones. We have corrections scheduled first, so I'm happy to present a summary of that and take questions, and then address the airport after that.
Please proceed.
Okay. So corrections, I'm the author of the Corrections and Special Purposes Zone Section 42A report and the corrections rebuttal statement. However, I did not draft the proposed plan provisions for the correction zone as I became involved in this topic in late 2023. So the Section 42A report addresses 4 submission points on the special purpose zones in general that do not relate to any specific zone. I do not recommend any changes in response to these submission points. In my view, there is a single notable issue in contention in relation to the correction zone. That is the definition of supported care residential activity and the associated references to this term. My Section 42A report supported deletion of the definition of supported care residential activity, but did not recommend any changes to the correction zone. This was because I understood that the Department of Corrections was satisfied for the zone to be retained as notified if the definition was deleted. However, I have now recommended several amendments in rebuttal in response to the evidence of Sean Grace provided on behalf of the Department of Corrections. These amendments are set out in Appendix 1 of my rebuttal statement. Mr. Grace's evidence recommends amendments to the introduction, Policy 2, Rule 4 and Rule 14 of the zone to remove references to supported residential care activity. In response, I recommend amending the introduction and Rule 14 as recommended by Mr. Grace. I also recommend amending Policy 2 and Rule 4 consistent with the intent of Mr. Grace's amendments, but with modified wording. In my view, my recommended amendments, as set out in Appendix 1, address all matters raised by Mr. Grace in evidence. I'm happy to take questions.
Thank you, Mr. Jeffries. First, initial clarification for me. Is the correction zone solely related to the Arahata site?
That's correct, yeah, that's the only place that it applies.
And is that designated?
Yes, it is.
And does the designation cover the whole of the site?
Yes, I believe so.
And this is a question we'll consider, and that's obviously much more live in the airport zone. But what's the juxtaposition of the designation and the corrections provisions? Do the provisions provide for anything that the designation doesn't provide for, and vice versa?
I believe some of the activities provided for in the zone may fall outside the purpose of the designation.
Can you give an example?
So there is, with my amendments, there's now limited residential activities provided for. So yeah, perhaps it could be argued they fall within the designation purpose, but they might also be outside it.
Now, understand the reason you shifted. Ground response to Mr. Grace's evidence. question that was exercising me was, given that we have now moved out of the ISPP, so we no longer have the ability to make out of scope recommendations, whether provision for residential activities generally, or as you qualified them as in scope. Like, I read your reasoning in paragraph 15 of your supplementary evidence, and I was a bit puzzled because as you record, the submission seeks removal of provisions and supported removal of the definition and the associated provisions applying to them. There seems to be quite a difference between removing all reference to supported residential care and inserting reference to residential care. The issue arose in the residential zones, but it didn't matter there because having removed the definition of supported residential care, that just meant that the existing rules for residential development applied. But this is different. There is no pre-existing rule. So take me through your logic. Why is a submission? How does a submission saying remove these provisions give any scope to insert new provisions?
I don't believe I'm inserting new provisions. There was some ambiguity in the corrections submission, which wasn't apparent to me when I wrote my Section 42A report. But I think Mr. Grace is correct that we have now changed this definition, and those activities that are provided for have the same effects, and it would be an awkward fit to leave that framing of them as residential care when it's the residential activity is the thing that concerns us, I think, from a planning perspective. It doesn't change the level provided. It's the same number of people will be accommodated. And I don't think there's an external reason to be concerned with the specific nature of that residential activity. I think from our perspective, we can view it as residential.
I should make it clear. I'm not arguing with the rationale as to why I think, like, we accepted Mr. McCutcheon's recommendation that there wasn't an effects-based rationale to distinguish between supported residential care and any other sort of residential activity. I'm interested in the technical issue of whether there is scope to insert provision for qualified provision, I accept, for residential activities. Is your argument, well, you've only deleted some of the provision, as you put a line through supported and care accommodation, and made consequential changes? Is that it?
Yeah, I think the scope comes from the submission point from corrections saying remove the definition of supported residential care activity and the associated provisions applying to such throughout the PDP. So while their submission was somewhat ambiguous, I think there is clearly a path here to provide scope.
And the other question I had is, if we accept that logic, should the should the provision for residential care be tagged specifically to Arahata Prison, given that the objective 01 obviously refers to Arahata, but limb 3, operational and functional needs to be located in the corrections zone. Should it be associated with corrections activities, or
It could be. The intention there was to, Mr. Grace's version of that policy, I think, provided a policy that was more expansive than what the rule was doing. So I wanted to bring that in a little bit. So I put in limited, so limited residential activities associated with the prison. So it could be, and I thought associated with the prison was not specific enough. So that's how I ended up with that wording with Arahata in there. But I think there's other ways you could achieve that.
like, as I say, I could envisage corrections activities that aren't actually part of the prison, that are sitting outside the security fence, for instance.
Yes. Yeah, and that is the nature of these.
And the question is whether, if like following the logic, as you say, the merits of providing for residential activities, whether it should just be Arahata associated, or a corrections activity that's sit on the Arahata site but not associated with the prison. That's what I'm thinking of.
Yeah, I think that is would be something different to what is going on here. So I think that I wasn't trying to move the policy too far away from the notified. So yeah, I was trying to make limited changes within.
Well, like ultimately, I'm thinking, well, supported, like we've accepted that there's no effects-based difference, but even if you look at supported residential care activities, that's not necessarily associated with the prison. But if it's taking place outside the security fence. And so my question, so the question I'm inviting you to consider, and you don't have to give me an answer right now, but you can respond in your reply. But the question I'm inviting you to consider is whether saying associated with Arahata Prison is too narrow, but that it needs to be, it obviously needs to be tied to corrections activities, because that's what the objective is about. And so a slight broadening for that purpose.
Yes, I think it could. Yeah, it could refer to corrections. That could achieve what I was trying to do there.
Commissioner Schofield, do you have any questions on this? No. Oh, sorry. I should have said, having asked Commissioner Schofield, he hasn't reminded me that before the hearing, but I'd forgotten that he has declared a conflict on corrections activities, and so couldn't ask a question. So we'll put that aside. I'll turn to my right, Commissioner McMahon.
Yes, thank you, Mr. Chairman. Good morning, Mr. Jeffries. I just want to come back a little bit and ask some more fundamental questions. Now, I appreciate you weren't involved in the drafting of the zone or the section 32, but I presume you're familiarised yourself with those documents. Yeah. When I read the objectives of the special purpose correction zone, and I compare those to the designation, and I should add that I'm not involved in the hearing stream on designations. I'm just wondering what the function of the correction zone is that isn't already achieved, that wouldn't already be achieved by the designation. And I ask that in a section 32 context because you've said that spatially the boundary of the zone and the boundary of the designation are matched, and that apart from this issue of residential activities, which you say might be covered by the designation, there doesn't seem to be any effective difference between the designation and the underlying zone. And what's your understanding of the rationale for having a special purpose correction zone as an underlying zone, other than the fact that designations have to have an underlying zone, and the National Planning Standards give a menu of the appropriate zones.
Yeah, we do need to have an underlying zone. There is significant overlap with the designation. So the other option available would have been to have perhaps a residential zone, and that was not the intention to create something a lot more enabling than the status quo. So yeah, there is a lot of overlap. So it's somewhat of a backstop to the designation.
Is that efficient?
I don't see it as inefficient. It's achieving what we need it to achieve. I don't see there's a better zone to do that.
What's the do you know what the underlying zone and the operative plan is for this designation?
I would need to look that up.
You know what the surrounding zones are of the designation and the proposed plan?
There is some residential and rural, I believe.
Can you recall whether the Section 32 looked at alternate zonings other than a special purpose correction zone?
I would need to look that up. I think it probably did. And thinking now, I think any alternatives would be less efficient if the objective is the same, to not be more enabling. I think, yeah, we would have to come up with something more convoluted than this. So it's an area where the activities enabled are pretty tightly defined. So I think that the prison zone, the correction zone, serves that purpose well.
I mean, I draw a distinction between, say, this zone, the correction zone, and the airport zone. I mean, both areas of land are presumably fully owned by the requiring authority. Correction zone, the land they don't lease it, or they have control over the land, presumably.
I believe so.
Yes. So, and the other requiring authority. So under Section 176, they can determine what activities can occur, regardless of having recourse to the underlying zone.
That's right.
Yes. And any works that they wish to undertake will go through an outline plan of works process.
Yes.
Without having to comply with the bulk and location standards and other standards in the zone.
Yes, depending on the designation conditions.
Yes, yes. Okay, well, and this is more of an inquiry on behalf of the panel as opposed to any particular submission, but I just wondered whether you'd address those issues. If you could come back to me with the information on the underlying zoning and the operative plan.
Yes.
And if you could confirm the zoning and the proposed plan surrounding the entirety of the site, that would be of use.
Okay.
Thank you, Trevor.
I suppose the follow-up question is, accepting all of the Commissioner's points, is there any submission seeking relief that would enable us to alter the zoning?
No, it wasn't challenged.
Commissioner Burge?
I'm just interested in your in policy 2, where you've included the word limited residential activities. And I just wonder, are you confident that in Rule 4 that provides the limit on what limited residential activities are? And if so, because you specify no more than 5 residential buildings, why is it even necessary to say limited residential activities?
Because the policy needs to operate independently of the rule. So if someone was non-compliant with that rule, they would have a restricted discretionary status that would go up to that policy. And before I made this amendment, if the wording had been provide for residential activities, I think that would have been too broad for what we were trying to do there.
And my only other question was just in relation to corrections have requested the inclusion of residential units rather than residential buildings. I just wondered what your view was on that.
Yeah, I didn't support that wording. I'm not sure if it was intentional, but it seemed ambiguous to me, and it seemed to shift it away from the proposed. And I wasn't trying to change it any more than necessary. So I think units could have been interpreted as dwellings. So I think it would have shifted the meaning of the word, perhaps unintentionally, of the rule, sorry.
So at the moment with residential buildings, you consider that a lot clearer than units, or not ambiguous?
Yeah, I think it's clearer, and I also think it achieves a different thing because the other wording could be interpreted as only 5 dwellings. This way, you can have up to 30 residents in 5 buildings. I think that could be more than 5 residential units or dwellings within those.
Can I query that? Because like the concept of residential unit is in the heart of the residential provisions. And I think it's pretty clear in the residential zones that a residential unit is just that, it's a dwelling unit. So you could have one building with 5 residential units in it. So a residential unit is more limiting than a residential building.
Yeah, that's precisely what I'm saying here.
And so you don't think it needs to be that, you don't think it needs to be that limited?
No, I just wasn't intending to change the meaning of the rule any more than necessary to change the terminology. So I didn't consider whether it should be more limiting than the proposed. My intention was to keep it as limiting as the proposed.
No, like I think it's the other way. If it said residential units, it would be more limiting than what is proposed, and that's what the department is seeking. And so I find that you're saying, well, no, we don't need to be limiting it to that extent.
Yeah, I'm not sure we're even in disagreement here. I'm not intending to change the provision from the proposed, other than to the extent necessary to change the terminology. So,
okay. Any more questions,
That was all from me, thank you.
All right, let's go on to the airport. So, same drill. We have Commissioner Schofield rejoining us.
thank you. So
if you could give us an introduction, and we'll go from there.
Thank you. So again, I'm the author of the Airport Zone Section 42A report. However, I did not draft the plan provisions or Section 32 report, as I became involved in this topic in late 2023. So the key issues in contention for the airport zone, as set out in my Section 42A report, are whether airport activities and airport-related activities should be addressed separately or merged through the definitions, policies, and rule framework, the relationship between the zone provisions and associated designations, the overlap between rules and standards, the general clarity of the zone provisions, and managing potential conflict between activities within the airport zone and surrounding areas. In my Section 42A report, I recommend a number of changes in response to submitters to address these issues. I note that the executive summary of my Section 42A report summarises the provisions I recommend amending. I've also submitted a statement of rebuttal in response to the planning evidence of Kirsty O'Sullivan provided on behalf of Wellington Airport. Ms. O'Sullivan's evidence supports a number of the recommendations contained in my Section 42A report. She notes a notable difference of view on only 6 key provisions. These are the definition of airport purposes, Objective 2, Policy 3, Policy 4, Rule 3 and Standard 3. In my rebuttal statement, I recommend further changes to Objective 2 and Policy 3 in response to Ms O'Sullivan's evidence. And I expressed openness to conferencing on the changes sought by Wellington Airport to the airport purposes definition, Rule 3, which covers non-airport activities, and Standard 3. On these points, we're in partial agreement with Ms O'Sullivan, but are still to determine the specific wording of amended provisions to resolve the issues identified. Ms O'Sullivan and I have begun discussions, but have not yet fully resolved the issues. I note that Appendix 1 of my rebuttal statement contains the most up-to-date version of my recommended amendments, including the Section 42A and rebuttal changes. I'm happy to take questions.
Okay, well, we might start with Commissioner McMahon.
Thank you, Jeffries. I'm just going to ask you a few generic questions and then hand back to the chair, and then I'll return with some additional questions on the matters that are still at large, if you like. So the first question is one of relating to the juxtaposition of the designation and the airport zone. And I see that the site is subject to 5 designations, and they're usefully listed in the track change version that you provided onto your rebuttal dated the 13th of February. Some of those are height limitations, others are land designations, and the ones that I'm particularly interested are the designation 2, which is the Airport Miramar South area, the Airport Main Side area, and the Airport East Side area. So they're designations 1, 4, and 5. And my question to you is there a complete match between the designation and the airport zone for those 3 areas of land? Or are there areas that are outside the designation or in the zone, or vice versa?
I believe there is a small area of airport zoned land that is outside the main designation on Bridge Street, but it is subject to the obstacle limited surfaces designation.
Okay, so it's okay, subject to an obstacle designation, but not a land. Is it a land designation or an airspace?
I believe so.
It's an airspace designation.
That's right.
Yes. Okay. So for all intents and purposes, though, there's a pretty good match between the zone boundaries and the designation.
Otherwise, yes.
Okay. And unlike the correction special zone, the I imagine that the airport will involve activities that are not always undertaken by the requiring authority, and that's why there is provision for non-airport related activities within the special purpose zone. Is that the rationale for that provision?
That's right. Yeah, there are numerous activities undertaken here by other parties.
And do you know whether those activities would enjoy the benefit of the designation, or are they reliant solely on the airport zone?
Well, if it's third parties undertaking the activity, they can't enjoy the benefit of the designation. So if it's not the airport, if it's not the requiring authority undertaking the activity, they would need to rely on the underlying zone.
Okay, so that would
just to qualify, is that entirely right? I thought the requiring authorities agents could exercise the designation. Isn't it a question of whether they're the requiring authorities agents or operating entirely independently?
For example, let's say a catering service that provides food for flights. They're not the requiring authority per se, but they're contracted to provide that service. And I understand that the site for that is the Broadway site, designation site.
Yeah, I'm not aware of the specifics on that aspect of designations. I'll take your word for that. But even so, I think there will be some activities that fall outside that agent of the requiring authority requirement. So I think it's still relevant in any case.
Give us an example so we know what the sort of thing we're talking about. What are you thinking about in your mind?
I mean, there's all types of activities undertaken in the airport, and yeah, I don't know which ones are within the designation. I don't think it's particularly relevant to this point. I think there will be some activities outside the designation, and they can use the zone rules.
Sorry, Commissioner.
Okay, so just to recap on that, if there's a need to comply with the airport zone rules because they're not covered by the designation, it could be via a number of reasons. One is it's not the activity is not covered by the designation either spatially, and you've indicated that's only a small area. Secondly, that the designation purpose doesn't cover the activity. So that's the first group. Would you agree with that?
That's correct. Yeah.
The second group that we sort of just touched on is whether the activities are covered by the requiring authorities themselves or their agent, or whether they are something completely different, like thinking of a courier operation that might be based in the airport.
Yes, exactly. I mean, there's a whole spectrum of activities moving from the ones most associated with operating an aircraft are clearly within the designation, moving away from that.
Yes.
To things that are, less related.
Okay. And the third group reason why an activity might not be covered by the designation and would need to rely on the special purpose airport zone might be that the activity and or its built form might not comply with any of the conditions set on the designation itself. And the evidence of Ms. Lester and Mr. Sullivan is that those conditions on the designation are many and quite varied and quite complex. So would that be another reason why the designation might not be able to be relied on?
Yes, that's correct. And that's a useful summary of.
So do those, in effect, do those conditions act as a sort of an umbrella to define the designation?
Yes, I think you could see them that way.
Okay.
Before you go on, Commissioner, can I ask a follow-up? That is, if the designation is replete with, as the Commissioner said, many varied and complex conditions, is it important that the zone provisions don't undercut those conditions to provide, in effect, a route by which the designation conditions can be worked around, to use a neutral phrase?
Yes, and I did burn my mind to that exact issue in considering this.
You want to elaborate on that, because I've got a follow-up question, and it's similar to the corrections one. Is if that's the case, why is the airport zone providing for airport activities, or in addition to non-airport activities? Why isn't the special zone just making provision for non-airport related activities and letting the designation do the heavy lifting in terms of the core purpose of the designation? And again, I know it's a little bit unfair asking you this question because you weren't the author of the zone, but I think it's a reasonable question in trying to understand the effectiveness and efficiency issue and the risk of acting and not acting. The risk of not acting in this case, not having an airport zone that provides for airport activities, is that a risk given that the designation is the prime means of providing for the airport?
So I think you've summarised that the circumstances where the zone might apply instead of the designation. So that's one reason to have that airport purposes. And I think that the zone should stand on its own, separate from the designation. The two do need to, they're obviously related and overlapping, but they are independent things. So we don't know what will happen to the designations in the future. So I think it is reasonable to provide a zone and for it to provide for airport purposes activities.
Okay. Would you accept though that if that's the case, it's important that the airport zone and the designation as they relate to airport activities are consistent?
I think they should be generally consistent. I don't think they need to be identical. And I don't think the zone necessarily needs to replicate every designation condition.
Okay. Do you agree that the airport could function without provisions in the airport zone that provide for airport activities?
It probably could. It may, certain activities, like you said, undertaken by parties that aren't the requiring authority or their agent, or things outside the designation, it may provide a pathway for those having the zone there.
Okay. Okay. I'm sure the requiring authority, when they present, will want to respond to some of those issues also through Ms. Dewar. I'm going to leave those general questions there. I want to return later on to the definition of airport purposes and airport activities and the status of non-airport activities, particularly on the east side precinct. I'll leave that generic question at this point. I know that the chair has some specific questions about the provisions.
Yes, I wanted to start with the precincts. I was a bit puzzled. Are these precincts in the National Planning Standards concept? In terms of the National Planning Standards?
I'm not aware of any inconsistency with the National Planning Standards and the
Well,
way they're framed.
Well, there are no objectives and policies that relate to them. That relate specifically to that, or not that I could find.
Okay.
Trevor, if I could just come in there, I should have just mentioned, Mr. Jeffries, that I have been involved in two of the designations that the airport have secured over the site, the main site and the east site, and also the site that's bounded by Broadway Street, which is the former Miramar Primary School site.
Okay.
And the concept of precincts probably existed in the old airport zone, but was certainly extended by those designations. So the designations rely heavily on the concept of precincts. Conditions relating to the designation are framed around the different precincts. So there's different conditions depending on the precincts. Is that the approach that the airport zone has adopted also?
The precincts are spatially identified and they're referred to in a number of the provisions. But yeah, not all provisions make a distinction on the precincts.
Yes. I was. Okay. Yeah. Okay. Okay.
Again, I'll just say that I did not draft the chapter and I was working within the scope of submissions.
Like we understand the point. Like,
yeah,
you're trying to make recommendations based on something you didn't draft, but the next, so as I say, I couldn't find any objectives and policies that related to the precincts. they're not on the E-plan maps, and they're not labelled as the National Planning Standards requires them to be labelled. So should they have, like, I understand they have a role in the rules. They have a role, as the Commission observes, in the designations. But as go back to where I started, are they precincts in terms of the National Planning Standards, or do they need to be identified with some other nomenclature? I'm not saying that they need to be deleted, but there seems to me to be some holes in the translation that the plan has picked up the designation wording, but not considered the implications of identifying precincts. So as I say, that's a long extended question with a lot of limbs. So over to you, how you respond.
Yeah, I don't think the way that precincts are framed in these provisions is the clearest way to do that. If I drafted the chapter, I would not have arrived here, but I only turned my mind to matters that were raised in submissions. And yeah, that's my role here, was to respond to submissions and improve these provisions as much as I could within the scope of that.
Just to pick up on the point just made by the chair, the policy for airport character does reference some in all of the precincts. So is the role of the precincts there to manage the character of certain parts of the airport zone? Is that how to read that policy? And the precincts there are to manage different areas of the airport that have different characters and therefore need different controls.
Or different activities.
Or different activities, indeed.
Yeah, that's what policy 4 does, I believe. And yeah, there are a number of other provisions that reference the precincts, but not every provision is divided on the basis of precincts. It is, yeah.
I suppose having worked through the residential zones that have specific objectives, specific policies, specific rules, specific standards for each precinct, this seemed like something of an afterthought. As the Commissioner said, there may be a reference that I hadn't picked up. Oh yes, yes, you're absolutely right. There is a reference there. The gateway status of these three precincts, the significance of the. So the initial premise, there are policies but no objectives.
And not mapped.
And they're not mapped, which seems odd.
There is a map.
But there is a map in the plan, but they're not on the E-plan.
Precincts.
That's right.
Yeah, they're not on the precinct section. They may be somewhere else in the legend, but it seemed odd that if they are precincts, they're not on the E-plan maps.
If I could just add to that, Trevor, the policy 4 references 5 of the 8 precincts.
Yeah.
Not all of them. For example, the SI precinct, the West Side precinct, and are not mentioned at all.
And we may get to a point where, as you say, you focused on the submissions which provide the relief to change it, and this may be just something we need to note as something that perhaps the council needs to look at further in a subsequent process. But I'm trying to get a sense, get an understanding of where these things fit in.
Yeah, I note your points on these. I don't think it's expressed in the best way it could be, the relationship of the precincts. And yeah, I'm happy to have another look at that and to report back if there is scope to change these things.
Like if you could look at, is there anything that can be done to address that? And sort of line it up a bit better with, as say, the national planning standards, and you go for it.
Trevor. A specific issue for you, Mr. Jeffries, I think, in relation to P4, is to explain to us whether it's intentional that the policies relating to airport character are are only of relevance to the 1, 2, 3, 4, 5 precincts that are listed there, and that they don't have, it's intentional that they don't have relevance to the other 3 precincts, being the SI precinct, the West Side precinct, and the Terminal precinct.
I can only judge that by the words on the page, but I think that's what it does.
Yes,
It
that's what it
defines
does.
some of the precincts, but not all of them, which I think is a reasonable construct. It may not necessarily be a specific aspect of those other areas that needs to be defined here.
Okay. If you're able to investigate that further, particularly in relation to whether the Section 32 canvasses the reason for the focus of policy 4. Because though the addition of the precincts are shown as red on my version, so they're additional. I'm looking at pages 1 and 2 of the track changes. That they're additions, presumably, that have come through the 42A process.
No, the precincts are not.
For the wording that I have in front of me on the bottom of page 1 and on the top of page 2 is red.
Yeah, there was significant changes made to the introduction, but that was just for clarity. Those precincts were all mentioned in the proposed version of the introduction. They've just been rephrased for clarity.
Okay, I see. I can see the strikeout at the end of that section. Now that did reference the previous precincts.
Yeah, they're going on. Thank you for taking to think about that. As I say, the answer may be, the ultimate answer may be it is what it is, and we don't have sufficient scope and submissions to change it. If that's the answer, we'd like you to tell us, because it does appear a little odd to me and inconsistent with the national planning standards. The other question I want to get on the table is sort of like a precursor for the issues that you dealt with in issue that you're talking to Ms. O'Sullivan about. So I want to understand how these rules work, because you've relied a lot on the fact that the rules separate activities on the one hand and building and structure activities on the other. But I look at rule 1, which is an activities rule, and you go to rule 1.2, the activity is land development and construction. The matters of control are construction effects, which doesn't seem to tie in with your logic of how you've approached these issues about definitions. And so I thought, can you explain to me what the thinking, well, you can't explain to me what the thinking underlying the provision is, because you didn't draft it. I understand that. But can you explain to me your interpretation of what is intended by how these rules are set up? Because I got awfully puzzled, and because we'll deal with it in greater detail talking about the airport purposes definition, but that seems to talk about construction as well, construction of buildings. And so I'm wondering, like, how does this all work?
So the general approach in the proposed district plan is to separate buildings from activities, and the proposed version of the airport zone did not do that. It was very muddled on this point. So I don't think it made a clean distinction, and I attempted to fix that through my section 42A. And I believe I did manage to untangle that mostly, but I take your point on the east side precinct. That doesn't cleanly divide that way. But again, I was working within the scope of submissions.
And can you remind me, like, obviously, the airport company are all over these provisions like a rash with suggested changes, but what was their solution? Did they unravel it? Did they solve that that problem? I'm not saying that their drafting might have been is necessarily a work of art, but did they solve that particular problem?
I'm not sure if they did, and I'm not sure if they attempted to, if it was even an issue for them. I mean, it's an issue of plan mechanics that may not have concerned them. But I would have to look at the recommended changes to see how they did that, or whether they even attempted to.
Okay. Yeah, and that might be in the it is what it is category. And you've done your, from your point of view, you've done your best to unravel it, but there might be some inconsistencies left over. Is that a fair summary?
Yes, I think it is. I think I've left the zone in a better place than I found it. But yeah, that there is some imperfections. So
Yes, sure that's the objective of the panel too, to leave the plan in a better place than we found it. I wonder if we should now go into the specifics of your recommendations, responding to submissions. Again, Commissioner McMahon, do you want to take the lead on this?
Yes, my primary inquiry here, Mr. Jeffries, is the terms, the three terms: airport purposes, airport related activities, and non-airport related activities. And understand the rationale for the first two. The one in the middle, airport related, I'm just not sure what the rationale for that is.
Do you want to reframe that? Because I think you said three.
Airport purposes or airport activities, airport related activities, and non-airport related activities.
It's the one in the middle.
It's the one in the middle, airport related.
Querying, you said the first two are okay.
Sorry, the first and third. I understand the rationale for them. I don't understand the rationale for the second one, airport related. And I just wondered whether there'd been any consideration to merging the two, or do terms 1 and 2 serve different purposes?
I believe they do serve different purposes. That there is a whole spectrum of activities undertaken in the airport. Some of those are clearly strictly related to airport purposes. It's anything to do with the plane, but there's a whole range of things moving away from that. And I guess the definitions draw some lines between those. The edges of those lines may be somewhat arbitrary, but they serve a purpose within the zone. And I think it is useful to have a distinction between airport purposes and airport related activities, which aren't the things strictly necessary to get an aircraft moving, but they may be legitimate things that support that purpose.
Okay, so what I'm understanding from that is that the airport purpose activities are the core activities associated with running an airport.
That's right.
Whereas the airport related are incidental to, or perhaps not directly core activities.
That's right.
Is there a relationship between those two groups of terms and the precincts?
No, not strictly, but some of the precincts do provide for the activities in different ways.
Yes.
So there's rules associated with each of these activity classes, and some of those rules make distinctions by precinct.
Can you give us ultimately I'd like you to produce a chart that actually distinguishes the activity status of the three categories that I referred to in the beginning of this question: airport purposes, airport related and non-airport related, and relate those to the precincts with and the activity status associated with those permitted, restricted, discretionary, whatever.
Yes, I can.
Can
I can
do that,
provide
but in the meantime, during this hearing, can you take us to a couple of examples where the rules differentiate between airport-related activities and airport activities or airport purpose?
Sorry,
And just on that is, I thought I read that the airport wanted to change the term from airport purposes to airport activities. Was that your understanding also?
That's right, and that's still something we may work through
Yes.
in conferencing.
Yes. Regardless of the term, it's the definition associated with the term that's important, isn't it?
That's right.
Yes. And airport purposes is the term associated with the designation, I believe.
Yes, that's
Yes.
right.
Okay. Is the term purposes used in other provisions in the district plan, or is there a reliance on the term activities?
I would have to get back to you to answer that.
Sorry, that's a little bit of an aside, but you were going to take me to an example of the differences between those three categories of activity.
Yes, so there's of those three definitions, each
Yeah.
has an associated rule, rule 1, 2, and 3. So rule 1 is airport purposes. Rule 2, airport related activities, and rule 3 is non-airport activities. And they each make distinctions, some distinctions by precinct.
Okay. So, for example, rule 3, non-airport activities are permitted where the activity is a golf course in the East Side precinct. So all other activities in all precincts are a discretionary activity, presumably.
That's right, for non-airport.
Yes.
It's nearly all discretionary.
But it then does trigger the non-complying in certain circumstances. How does that work? Because that's, yeah, why would a non-airport activity trigger to non-complying? What would be the circumstances?
Non-compliance with the standards.
Okay,
Particularly
standard 3 and 4.
Yeah, that's right.
Okay. Okay. Just not too sure how to take I've focused on the areas where there was still some potential disagreement between you and Ms. Sullivan, Mr. Jeffries, and you've outlined those in your rebuttal evidence. And each time you've said that you'd welcome the opportunity to conference on those matters. And this morning you said that you've kicked off that process of conferencing with Ms. Sullivan, and but it's not complete. Still needs some specific wording solutions to work through. Does that mean that on matters such as these terms, the status of non-airport activities, whether they are discretionary or restricted discretionary, and the policy issue, the standard number 3 issue, are they all resolved subject to the wording being agreed, or is there still a fundamental disagreement on those 3 areas of dispute?
I don't believe it's a fundamental disagreement. In each of those cases, I've agreed with Ms. O'Sullivan to some extent.
Yes.
Yeah, it's the specifics that we haven't fully worked through, and that's just a matter of time. If I'd had time, I probably could have got there on those, or figured out a wording that I would be satisfied with.
Okay. Okay, that puts us in a little bit of a dilemma because ultimately we'd like to give the opportunity for that to occur. And then would encourage that sort of resolution. Mr. Chairman, I'm just in a little bit of a quandary here as to how far to take this now.
Well, I wonder if we should. I think we should tease out the basis for Mr. Jeffrey's current position.
Okay.
And if that changes, then we'll address it. We'll figure out where that takes us.
Okay. Okay. Well, on those three issues, Mr. Jeffries, what I'm interested in is on the first issue about the airport purposes. What I'm interested in is getting terminology that's consistent within the district plan. So if airport activities is a better term than airport purposes, that would be nice to hear that from you. As to the definition, well, it'd be very useful for you and Ms. Sullivan to come to an agreement on what that might be.
Yes, and it like I say in my rebuttal, I agree in principle with amending that definition to remove reference to the designation.
Yes.
But it's the specifics of the list Ms. O'Sullivan has provided that I'm unsure of, and want to work that through and make sure I understand all the consequences of it.
Yes. Well, that does go back to that very first inquiry I put to you as to what's the purpose of the airport zone in relation to the designation. And you said important. It's not essential that there's complete fit between the two, but it would be desirable that there was no major misfit. I think I heard
Exactly.
you say.
Yeah.
I think I think we're now talking about what you will report back in following conferencing or in reply. But from my vantage point, I would like to be satisfied, as you said, that there is no material difference between what the zone provides for through the definition of airport purposes and designations.
Yes.
And no material designation conditions have been sidelined in effect by a side wind. Too many sides there, but you know what I mean. The list of activities enlarges the designation. I think we'd want to know that. And similarly, that to the extent the designations constrain activities, if the definition pulls them back in, I think we'd want to know that too.
Yes.
But there is a materiality threshold here. So I'm saying use your judgment and as to what's likely to interest us, but that's the direction certainly that I would ask for. I want to know what are the material differences, if any, between what that definition provides for and what the designations provide for.
Yeah, I agree with that. And yeah, I didn't yet have time to consider every word of the definition put forward by Ms. O'Sullivan, but I understand that she was attempting to make that consistent with the designation, that those were matters mentioned in the designation, I believe, but I would need to look closer at that.
Okay. Okay. The second issue for me is the status of non-airport related activities. And this is covered in your rebuttal at paragraphs 22 to 26. You say that you're a little bit unclear on some of the issues about the difference between retaining a discretionary activity status within the East Side precinct or applying the RDA status. And you said you are open to considering an RDA status for non-airport on the East Side if the case is appropriately made. Presumably that's going to be the subject of a discussion between you and Ms. Sullivan.
Yes, from my discussions with Ms. O'Sullivan, I don't believe she does want to pursue that.
Okay.
But my comment was I didn't really understand if she was aware of that discrepancy, that
Yes.
that's not part of the status quo of the operative plan.
Okay.
And it turns out I don't think that was intentional. So I believe we can get there with the discretionary status in the east side precinct.
Okay. If you can't, the issue for the panel is why is discretionary activity status more appropriate than restricted discretionary? What would it achieve that restricted discretionary activity status wouldn't achieve? So if you can't get resolution with Ms. O'Sullivan on that, then it would be useful to have that logic set out for us.
Okay.
The third issue was the issue, and you cover this in your one. This is covered in actually this is. I don't know if it's still outstanding, but it was certainly something that Ms. Dewar in her legal submissions raised at 114, and that was the role of the design guide in policy 4. Is that still a live issue?
I'm not sure of Ms. O'Sullivan's position on that. It didn't come up in our discussions so far. So whether she has accepted my position there, I'm not sure. You would have to ask her, or I can clarify.
I think the message from Ms. Dewar's submission is that it's still live.
Yes.
And essentially, Ms. Dewar's point is that the suggested reference refers to the intent of the CMUDG, and the way that the design guides have been rejigged, the reference to the intent is reference to a very specific provision in the design guide, which only refers to the centres and mixed use zone. So the question is, how would the proposed policy reference actually work? Because there couldn't be a problem with consistency with the intent, because the intent doesn't apply to the airport zone.
I would need to look at that closer, but I believe there may be a link back within the design guide that refers to any provisions that refer to it. So that I believe there is something there, but I would need to look closer to confirm that.
Well, maybe then, like as the Commissioner said, it's important that these references are consistent, and through the design guide review process, the term of art was consistent with the intent, but the intent in this case doesn't apply. Like, this could have a different reference, a different way of referring to the centres and mixed use design guide, refer to the vibe of the document, but that would stick out as being contrary to the recommendations from the design guide review process that the hearing panels recommended be accepted. So is there a bigger problem? Like, there's both a technical problem with how it's referred to and a consistency problem if you move away from that.
I would need to look closer at that. I understand that design guide it has some pretty broad principles that could apply to something like the airport, but noting that it is framed as a centres design guide. A potential solution could be an amendment to that design guide if it doesn't work, but I'll need to look closer at all the pieces here.
Could you also give some consideration to whether deletion of, just get the reference, clause 2 of policy P4 might be appropriate, given that the matters, there doesn't appear to be any cross-link. There is a cross-link in to construction or additions or alterations to building structures to P4 as matters of control. And there seems to be a cross-link on the matters of discretion also, I think, under subclause 3. Okay, so there is a reference back to P4 as matters of control and matters of discretion in the rules. But if the clause 2 of P4 is flawed, how does that work? And given that the assessment matters on the standards at least talk about urban design and visual impact, would that be sufficient in the absence of any reference in P4 to the urban design guide? And that would be something, I think, if you could discuss that with Ms. O'Sullivan in your conferencing, that would be useful.
Yes. Okay.
The final matter was standard number 3, and you've covered this in your rebuttal paragraphs 27 through to 31. And primarily when you were talking about a change to clause 1B of standard 3, and that's still a live issue, obviously. But then you went on usefully to talk about clause 3.2, and you said that it wasn't an amendment that was sought by the WILE submission, but you accept that perhaps some amendment might be useful. Could you just take us through the rationale for that, please?
Before you go there, can I point out a glitch that may have misled you? I got awfully puzzled with this. I read Ms. Dewar's submission saying, well, no, there's not a scope problem. We sought deletion of the whole thing. And I went back to Wellington Airport's original submission, which, as you observed, was rather unhelpfully an absolutely clean rewrite.
Not tracked,
which did not include 3.2.
okay.
But the marked up version that's in
That's right. Index C.
your 42A,
Index C.
which I understand Wellington Airport provided to you, did include 3.2. So I wondered if that glitch has misled you.
Yes, it has. Yeah, that's exactly what's happened here. So there's a discrepancy between the track changes provided by the airport after the fact. That was meant to be identical to their submission. So that was the version.
That would be the understatement of the year.
Yeah. So that's the source of it. So their original submission did say that. So I don't know where that leaves scope. But
I think the original, starting point's clearly the original submission. They could confine their original submission, but this reads more like a cock up rather than a shift in position. It was just a mistake in preparing the markup. But so assuming, like, that's how I read it. Obviously we're going to talk to Ms. O'Sullivan about this and say, but on the assumption that she will confirm my suspicion that this is just a transmission error.
She has confirmed that. That's exactly what it is. And in my discussions with her, I drew that to her attention, and I said they may want to consider where that leaves scope. And her position was, we'll put scope to the side and proceed on the basis that there is scope in those discussions. So I think we're getting a little closer there, because I do agree on the substance there.
I think that's an entirely appropriate position for you as planners engaging. I think that we'll discuss scope with Ms. Dewar, and whether, I suppose, as I say, whether that error alters the position or doesn't. But clearly the starting point is what was in the original submission. So I think the working assumption is there is scope to change it. The question is, what's your view on the merits?
Yeah. And you've given a preliminary view on that in paragraph 31 of your rebuttal. That's subject to scope.
That's right. And it is another case of there not being a clean distinction within the plan rules, of things being in their proper place. It's drawing activity matters into the standard, which I don't think that's a good fit. So the solution may be to delete that from standard 3 and check that the associated rules cover that matter sufficiently, or whether they need further amendment.
Okay. Well, they were the four issues that I had identified as still at large. Hopefully that's of some assistance for your conferencing.
Just check my notes. I suspect you've dealt with most of the issues.
There's one little minor matter. I'm just intrigued why don't agree with Ms. O'Sullivan to change airport purpose to airport activities. It sort of stands out as something quite different compared to the other. Sorry, I should have that on. It's quite different to the other special purpose zones where they're clearly activities. So why not just say airport activities, and then that matches non-airport, airport related activities and non-airport related activities.
I most likely agree on that, but I haven't had a chance to go line by line to see if there's any unforeseen consequences of that. So I would like to do that, but most likely agree.
Another one is I'm the only panel member here who was on hearing stream 5, which included noise, airport noise. Could you just check? You've deleted the little section in the introductory part around noise, but from my memory, that wasn't proposed to be deleted as a recommendation. There's a section there that talks about the airport noise.
Yes.
Could you just check whether and confirm whether or not you are recommending to delete that paragraph, that section?
Well, I suppose the other thing is whether you are, and if you are, why?
Yes.
Yeah, the changes to the introduction were generally for clarity. It wasn't intending to make any substantive changes at all. So
there were some
if it has a substantive consequence, then
there were some changes recommended through the noise hearing. Hearing the submissions on noise provisions, but it wasn't recommended to be deleted as such. So could you just confirm that for me, please?
Just on that, I wondered about that also, because it doesn't relate just to noise, it relates to other matters. And on page 4 of the provisions, there's a title that says other relevant district plan provisions, and it says there may be a number of provisions that apply to an activity, building, structure or site. Was it intended that would pick up the noise standards or airport noise, or not?
Sorry, could you repeat the question and
the provision
me to the text that you?
Yes, the provision is entitled other relevant district plan provisions. So it sits just before the objectives.
In the introductory text?
Yes.
After the introduction.
Oh, yeah, sure.
At the very end.
Yeah.
And I just wondered what the intention of that was. Presumably the noise provisions sit outside the airport zone, and they're a district-wide rule, are they?
That's right.
Okay, so in relation to Commissioner Schofield's question, would that text cover the deletion of airport noise on page 3 of the introduction?
I'd have to have a closer look, but the intention with the amendments to the introduction were just for clarity and to not alter substance, and actually to not Yeah, to let the objectives and policies do the work of, if it is having a substantive effect on anything.
So presumably there are other district-wide standards other than noise that would apply to the airport, transportation, subdivision, earthworks,
Yes.
etc.
Is it an issue of degree? Like the airport noise provisions are solely related to the airport and work intrinsically in tandem with how, well, are intrinsic to how the airport works. Whereas, as the Commissioner said, these other district-wide provisions apply to the airport in the same way that they apply to everywhere else.
Yeah, perhaps that is the case. I would need to look at it closer. I'm not sure if there's an issue with the wording here, but I can look closer.
Another minor question. Thank you. You're recommending some changes to objective 2 around the higher standard of design may be necessary where large buildings or structures are visible from, and you're recommending the words adjacent public roads or open space. And I just wonder about how open space is a term. You're not referring to open space zones. It's not defined as such. So open space could be quite broadly interpreted. So I'm just wondering, like up on the hillsides around Strathmore, for instance, or over towards Melrose and things, there are areas of open space that aren't zoned open space.
Can you remind me where that provision is?
There's objective 2.
Oh, yes. Yep.
And clause 3.
Sorry.
So what's the specific question?
Well, the specific question, you're recommending visible from adjacent public roads or open space. No doubt we will get some submitters on this point, but open space is quite a wide term. You're not saying open space zones, you're just saying open space. What is open space? Is it public open space? Is it private open space?
I had in mind public open space, and it's somewhat limited by the word adjacent. I think the wording suggested by Ms. O'Sullivan was overly broad, the public domain. So I was trying to bring that back in a little bit.
Okay. Well, is the air over the top of the airport open space with a small O and a small s? Because that was her concern with where the plan started. Because the text in the notified plan was visible from the public domain, and she was saying, well, people looking out the plane, that's the public domain. As it flies by at however many thousand feet over the top of the airport, and so you're winding that back, like she was talking about reserves. And I understand you saying, well, that's too narrow. It needs to, because there are some things like you have, as the Commissioner said, open space zone. That's not necessarily a reserve. It is open space with a small O and a small s. Pulling the pendulum too far the other way. And is there a better term to capture the kind of places that you have in your mind?
Yes, perhaps a better term is public open space, because it's not intended to apply over the airport. And if that's a possible interpretation, I hadn't considered that, but I think public open space solves that
Well, what
issue.
a public open space land?
Yes, that could, yeah.
Sorry, Commissioner, have you have anything else? Anything else on your list? while the Commissioner's talking, can I take you back to these definitions? Given the way you've described how the plan is supposed to work, the rules, it's obviously important to distinguish between airport purposes or airport activities, whichever the head term is, and airport related activities. And it's important to have a boundary. You said that the boundary is somewhat arbitrary. I understand that. You're talking about where you are in a spectrum, moving along the spectrum. Should the definition of airport related activities have somewhere a statement that it's referring to activities that aren't airport purposes or airport activities? So your core, you start with the core, and you have a rule that provides that core, and then you're moving to the next state, ancillary, but not part of the core. Would it be clearer if the airport related activity said specifically that's not airport purposes or airport activities, wherever you say?
Yes, that could be clarified, because I guess there is two different things. That they're distinct circles. They're not. It's not a bigger circle that encompasses the smaller one. They're two different circles.
Because you like that. That was where I was going to go, because you have different rules with different activity statuses. It's important that you know which bucket you're in.
Yeah, they're distinct buckets. They're not overlapping, and if that's not clear, then it should be clarified.
Got the Mr. Clifford, you're good. Going back, you were discussing the airport's general submissions about the cross-reference to the coastal environment overlay, and you may have talked to Ms. O'Sullivan about it, but I wondered whether you were misreading the submission. They're not saying that the airport zone should come out of the coastal environment overlay, because that produces the problem you've identified. There's then no underlying zone, but the reverse, that the coastal environment overlay shouldn't apply to the airport zone. Now, the answer in turn may be, well, that's an issue for the stream that will consider the coastal environment, but if that's the correct interpretation of the submission, what's your response?
Yeah, I believe Ms. O'Sullivan has addressed this point, and her position was that the submission point should not have been coded to the airport, that it should be addressed through the coastal environment. So I believe it's no longer in contention for the purpose of this hearing. But I was dealing with what was in front of me. Yes. It was coded to this zone, and the wording was ambiguous. But I don't think it's really a live issue.
Well, not a live issue for this hearing, likely to be very live in the coastal environment hearing.
Exactly.
So I wonder if the formal response is that submission needs to be transferred in terms of transferred from this stream to the coastal environment stream. I've forgotten which one that is.
I'll check that, but I believe it is already picked up there. I think it was coded to both, but I can check that and confirm.
Can you please do that? paragraph 98 of your 42A report, you've suggested accepting whilst amendments to the airport related, or some of them, the question for you, going back to 92, which sets out their relief, are two questions. The first in F, if you're going to accept, should the word be activities in the plural, the first line?
Of which clause, sorry?
F for Freddie.
Looking at paragraph 92.
Yes, your relief, which I think you recommended accepting. But if you're going to accept it, should it be activities? And the second question is, what's the difference between hotel and visitor accommodation? I would have thought that hotels are a subset of visitor accommodation, but are they distinct activities, distinctly defined activities? I haven't checked.
I haven't checked that. I'll need to check the definitions.
So can I just invite you to ponder that? The discussion of the amendment to objective 4, you've recommended acceptance of while submission, and intrigued by the fact that the end result is that there's no reference in the objectives to managing reverse sensitivity effects. Is that because the airport owns all the land and controls everything that goes on within the airport zone, and the
Just need to have a look at this.
so that's paragraph 141 for your 42A.
The issue was that the objective referred to effects management outside the airport zone. An objective of the airport zone has no ability to manage effects outside the zone. So that's what that amendment was, as one of the reasons why I accepted that amendment.
Yeah, I can understand that point, but the end result is that there is then no reference anywhere in the objectives to reverse sensitivity, and given that that's normally a key issue for big infrastructure players like the airport, like the port, like Transpower. I've heard this quite a few times before. I was interested that was their position. And do you think that the reason for that is that they control everything within that zone, so it doesn't matter?
Well, they have a pretty broad ability to operate. I think that the term and the concept of reverse sensitivity is often misused. So I'm not sure how useful it would be in the objectives. There is reference in the objectives and policies to effects on adjacent zones. So that's perhaps a better aspect of it to think about.
Yep. Well, there are sensitive activities within the airport to going on the other side of the zone boundary. But I suppose that would need to be managed in the neighbouring zone provisions rather than the airport zone anyway, wouldn't it? I think that's your point.
Yeah, if you want to manage something in an area outside the airport zone, you'll need to manage it through those zones. That's correct. But if it's an effect coming from the airport, then it is within the power of that zone to manage that.
Just to pick up on your port zone has objective 1 and cause 2, and it refers to reverse sensitivity in there. I'm just trying to think whether there are, well, it's within the zones, so it shouldn't be. Whether there are wider controls outside the port zone that relate to that objective. But
that might be an issue for your colleague to ponder over the morning tea break. Going to objective 5, you've recommended not replacing options with operations. If, as you recommend, that text shouldn't be changed and it should remain options, is there an argument that it should talk about significant growth in adoption of integrated low carbon and transport options? Because just enlarging the number of options doesn't mean anything's actually happening. And of course, objectives are about what is the outcome. Basically, what do we care if there are multiple options if no one's taking them up?
I'm not sure I understand the question.
You've said that land transport options makes more sense in this context. My question is, growing the number of options doesn't mean that those options are being utilised. It does them if you retain options. Is there a case for amending it in another way to talk about adoption, significant growth in adoption of integrated low carbon land transport options?
I guess you could put it that way. I don't really see an issue with the wording as it stands. Yeah, it could be, take up of alternative options, maybe, that could clarify that. I'm not aware of anyone seeking that change. I'd have to have a look at the submissions.
Well, that's the effect of the change that Weil is seeking. If you convert that from options to operations, you're talking about growth in things that are low carbon. So I think that would be a different way of providing for their relief if you think that it's important to retain the word options. It just seemed odd to me that you want to grow your options but say nothing about the take-up.
Yeah, that's a possibility. I believe it was actually a mistake that they put operations. I discussed this with Ms. O'Sullivan and she didn't want to pursue this point further. She was happy with that wording. And I don't believe she addressed it in her evidence.
Yes, I suppose my concern is maybe if you reflected on it and decided that the airport was being too generous and expanding the number of options gave them more flexibility with what they did. But like if they haven't withdrawn the submission, it's still on the table. So hence I'm inviting you to consider it further. And if you come back to us and say you've thought about it and that think it's fine as is, then consider it on that basis. The consequence I was puzzling about the revised versions to your rules. This is my last question. The seemed was left wondering, is there a problem taking out reference and to well, looking at your rule 1, you've suggested deletion of S1 and S2 in rule 1.3. Now, clearly there's a problem with the fact that the permitted activity rule doesn't refer to those standards. So there's a mismatch between the permitted activity and that might be what you were referring to when you're talking about cleaning up the logic.
Yeah, partly. That was mainly about, again, that division between activities and buildings. S1 and S2 both relate to height and location, which aren't related to activity as distinct from a building. So that my intention here was to make a clearer distinction and to pick up those matters through Rule 4, which addresses building and structures.
That's all I had. Commissioner Burge, you've been remarkably quiet here.
Interesting listening to, most of my questions have been answered, but I do have a couple remaining. One was to do with policy 4, and I know Commissioner McMahon did have a discussion with you about it, so you may have answered it. I just wanted to understand, there's one of the submitters has asked for the reference for West Side precinct to be included. So I just want to understand why some precincts are listed and some aren't, and why that submission was rejected.
Generally, I was not seeking to depart from the proposed intent on that. So, yeah, I didn't see that there was a specific characteristic of the West Side precinct that needed to be articulated in the policy.
So just also on clause 2, you've got the intent of the centres and mixed use design guide, just a typo, that should have a capital T beginning.
Okay.
Who was that, sorry, Commissioner?
Clause 2 on B4.
Oh, yeah.
Just that needs to be capital. In relation to P5, you've deleted clause 7. And as I understand it, part of the reason was because it duplicates a designation condition.
That's right.
Sorry, I'm just reading this. Sorry, my computer just jumped. I'll sort of find myself again. So in the standards, you know, if that's your reasoning for the deletion of clause 7 was because it's a duplication of a designation condition. Standard 1, you've used the opposite logic, and I'm referring to your paragraph 264 in your 42. Where you don't support the deletion of the clause in the terminal precinct no closer than 20 metres to an external site boundary. And part of your reasoning is because it replicates a designation condition. So I just wanted to understand your logic about where's the distinction between what designation condition is repeated in the provisions and when it's not. If there's a rule of thumb there, or if it's depending on the condition, or
in neither case is the fact that it's a duplication of a designation condition the decisive factor. It's whether it's useful to duplicate it. I believe I've said it in my section 42A report that it's that there is some overlap, that the designation and the zone do not need to be identical, but in some cases it will be appropriate to duplicate conditions. So the second one you mentioned is a trigger for consent. So I found that was useful to leave that there for that purpose. In this case, the clause mentioning reporting on decarbonisation, I didn't find that a useful condition to duplicate in the resource consent. So I have given some reasons. So
yeah,
that it is sufficiently covered by the designation and that there's not an aspect that needs to be picked up in the rule. So, and it would be impractical to implement at the resource consent level.
I just test that. I think the logic of impracticality is that this is about third-party applications. What happens if while applies? Is it impractical?
Would that be held by the designation condition?
Well, no, because if they got a resource consent, they could operate independently of the designation. They can pick and choose which direction they go
in. That's unclear to me, and if there's an issue there, it's perhaps worth getting some legal advice on that point. My understanding, and I have discussed this with Mr. Whittington, is that the designation condition would apply. I did consider your interpretation and put that to him, so I understand that the designation condition would apply. It does seem somewhat ambiguous legally, so perhaps we need to clarify that.
Well, I wonder if we should just ask you, as part of the council's reply, can you ask Mr. Whittington to document his advice? Like, it doesn't have to be extensive. I'm not looking for a tome on the subject, but I want to understand his reasoning.
Yeah.
Right, Commissioner.
That's fine. Just final, there was a request for a new Bridge Street precinct. And I know you talked about that with Commissioner McMahon, but I just want to see if I've got my understanding right, which you didn't support, and you say that that area is within the Airside precinct, but it's not included in the main site area designation. Is that what you were going to confirm with Commissioner McMahon, or did I get that slightly wrong?
Yes, I did say I would confirm that. I believe that's the case, but I would need to look closer. I believe it's not in the designation. It's not in the main site designation.
Yeah. So you've noted that the obstacle limitation surface designation limits, building heights and development. Do you consider that that goes some way in addressing the Guardians of the Bay submission point?
If I'm remembering correctly, I think their concern was that that could enable buildings to be placed in that area. which the obstacle surfaces is highly constraining, so I don't think it would be practical to do that. And a related point is I understand the airport's intention in this area is not to build, is to use it for runway requirements. But you're correct that there's not much else in there to constrain activity in that area. Or to constrain it in a different way to the airport runway. So yeah, perhaps that is something that would be worth taking a closer look at.
Can I ask you, my understanding the OLS as it's been described to me is that there is across the entire city, there are multiple height standards. And if you impinge basically height, maximum heights, and if you impinge on those standards, you need WILE's agreement. Isn't there a fundamental problem that if WILE's asking itself for agreement, it's highly likely to agree? So that's a practical issue. And the second question is, what is the relevant height at which the OLS cuts in that area?
I believe I referred to that in my section 42A, but it's very little, like below 2 meters, I believe. So you couldn't get a building in there. I guess the airport could go around their own designation, yes. Yeah, I understand that that's not the intention because they need that space for civil aviation requirements on runway width. But as I said, it's worth a closer look at this issue, I think, of whether there is a distinction needs to be made between Bridge Street and the rest of the airside precinct.
The definition of obstacle limitation service isn't proposed to be deleted or anything, is it? No.
I did support the definition of
Retention of the definition.
No, I have recommended deleting it in response to submission from the airport. And that was because the only place in the district plan is referred to as in the designation, and the designation, they didn't want the designation to be bound by a district plan definition, and the term is sufficiently described in that designation. The only other place in the plan that it's mentioned is the airport zone introduction, and it's also sufficiently described to render a definition unnecessary. So it was my view that it could be deleted without consequence.
So
Any
that was
more
all
for
I
any
had.
more?
Thank you.
Two from me, Mr. Jeffries. The first one I think I've answered myself, but I just wanted to check with you. When I was looking at the mechanics of the rules, I was wondering why rule 1, 2 and 3 didn't reference standards 1 and 2, which are the building heights and that. But I guess the answer is found in rule 4, which deals with the construction additions and alterations to building structures, which does reference standards 1 and 2. Is that the answer?
Exactly, and that was that issue of trying to unwind that kind of confusion between activities and building and structures.
Okay, and that's why rules 1, 2 and 3 refer to standards 3 and 4, which are more activity related as opposed to structure related.
Yes, exactly.
Yes. Just on rule 4, the 1A Roman numeral 1 uses the term or And I wonder whether that should be and.
One,
This is under Rule 4.
Yeah.
1A, Roman numeral 1.
Yeah.
Compliance with standards, airport standard 1 or standard 2 is achieved. Now, it's probably splitting hairs a little bit, Jeffries, but I'd hate to see it that the airport could argue that that they apply with standard 1 and therefore, but don't apply with standard 2. But because of the term "or," they only have to apply with one or t'other. What was the intention there?
No, they should only apply one or the other because they apply spatially. So there's no places where there'd be an option. So the "or" is correct because standard 1 and 2 cover the same content, but apply to different spatial.
well, so is the, would it have the same effect if it said 1 and 2 as applicable? But like from your reading, it makes.
Yeah, that's the intention.
Explaining they are actually alternatives in practice.
Yes. That's not an alternative that's ever available because they apply to distinct spatial areas.
Okay. Thank you. The second matter is more about where to from here. Are we going to hear from the airport presumably tomorrow? Wednesday?
Yes, I think it is tomorrow.
And I just wondered, we could canvass the same matters for them, but it might be more useful if we had some definitive position from yourself and Mr. O'Sullivan ahead of that.
Like if that's possible.
Yeah.
And I suppose the reality is that we're adjourning it at the afternoon tea break, so two of us can do other things. If you're able to make progress this afternoon with Ms. O'Sullivan, I think we'd urge you to do that because it'll make our discussion with her much more efficient.
Yes, and I have been progressing those discussions, and I think they are moving as fast as they can. So
like we understand there are moving parts. It's quite detailed, and I think the request would be focus on the low hanging fruit, and so that if there's something that's going to take more time, then put it to one side, and so that we don't go around the houses with Ms. O'Sullivan, that the pair of you are confident that you'll be able to resolve.
Yeah, I believe it's pretty narrow that what's not resolved, and I can make that clearer. I can make the unresolved parts clearer so that you're not that you're only working within that.
That would be of assistance. Anything else, Commissioner?
Thank you.
I think we'll now break for our morning coffee. It's somewhat late, and we'll come back and talk to a colleague about statements.
Thank you.
Adjourn we'll be back at 11:20. So we're up to the stadium zone. So over to you.
Cool. So a lot of familiar faces, but for the benefit of anyone listening online, my name is Hannah Van Haren Giles, and I'm a senior planning advisor in the district planning team. So I'm the reporting officer for 6 topics as part of hearing stream 6. And we'll begin with the special purpose stadium zone, port zone, and quarry zone. So for the stadium zone, there's one recommended amendment in my section 42A report, which is to delete reference to ecological values because there are none in what is a highly modified stadium zone. There's no further evidence on this chapter and no outstanding matters. So I'm happy to take any questions if there are any. Otherwise, we can move on to the quarry or port.
Just to clarify, my run sheet says you've already talking to us about the port zone. Like, we're nothing if not flexible, but
Got stadium zone first and then port zone.
Outside. Side of your sheet. Down
yeah, stadium first,
Yeah.
stadium and port.
Stadium and port, and then quarry, if we get to it, depending on
Okay,
time.
I gotcha. Okay, stadium, we have one recommendation only, no evidence, nothing. Any questions from the panel? No. Next.
Cool. So next, in your hands as to whether you would like port or quarry. The run sheet says port, so.
Well, let's, Jazz has decreed we're going to be talking about the port zone.
Okay, fantastic. Okay, so the port zone replaces the ODP with a tier precinct, including the operational port area and the port redevelopment precinct in the operative central area zone. I can briefly run you through the different precincts and
Yes, so
where they're
if you could
located.
give us an overview of how these versions are set up, that would be good.
Yeah, absolutely. So the port zone itself occupies a large prominent area at the entrance to the city. It extends to the west to include areas occupied by rail yards and freight activities and is bordered by the city centre and waterfront zone. The port zone includes the commercial port area where Centreport operates and extends from Kaiwhatawhata in the north to the railway inter-island wharf in the south. And within the port zone, there are 2 distinct precincts, being the multi-user ferry precinct in the north and the inner harbour port precinct in the south. So the inner harbour port precinct is an area of land to the east of Waterloo Quay and south of the commercial port. And this precinct closely aligns with the port redevelopment precinct in the operative district plan. The multi-user ferry precinct covers the area in Kaiwhatawhata to the north of the commercial port, which contains the existing Inter-Islander ferry terminal. And both the extent of the precincts and their names were developed through discussions with Centreport, and there is no submissions or any amendments to the extent of the port zone. So I can step you through the key recommended amendments in my 42A.
I wonder if before you go there, if you could please talk us through, like, I think that there's I think I understand it. Well, I certainly understand what the multi-user port zone, port precinct is for. That's sort of almost self-evident given where it is and the now abortive plans to upgrade it. But talk to us about what is the underlying intention of the inner harbour port precinct, and how does it differ from the balance of the port zone that's next to it?
Yep, so to go back a step, the underlying port zone provides for, the intent is to provide for the continued safe and efficient operation of the commercial port and operational port activities. To briefly cover the multi-user ferry precinct is to primarily enable the continued operation of the Inter-Islander ferry operation. Both precincts and their intent and long-term vision have been developed through discussions with Centreport since early 2020. The intent is that the district plan reflects Centreport's regeneration plan, which is that in some shape or form that there is a multi-user ferry terminal located in the multi-user ferry precinct, or for short, the MUF. Whereas the Inner Harbour Port Precinct, or IHPP, is intended to transition to a mixed-use waterfront environment. So it's intended to have more of a commercial and office activity function rather than in the long term be a passenger port area. So the intent is that Bluebridge eventually at some point may or may not, depending on how the consented IREX project ends up, Bluebridge may or may not shift to the multi-user ferry precinct, at which point the IHPP will transition to a more mixed-use waterfront environment.
Is the reality that following the announcements about the IREX, that transition is now probably significantly further away than it was when these provisions were envisaged?
I don't think it necessarily changes what the provisions for the multi-user ferry precinct are. I think, yes, it puts into question the certainty and timeframe of if and when that may occur, but I think it's always the intent, as I understand it, of Centreport that there is a multi-user ferry terminal of some shape or form. But I think through the evidence of Centreport, they have raised some issues that were not previously issues with the chapter, and I think maybe that reflects that kind of uncertainty that they're just wanting to make sure there is that scope for passenger port facilities to continue in the IHPP, given that uncertainty of Bluebridge shifting in the near future.
Things they might have been prepared to live with in the expectation it would be a short transition may no longer be quite so acceptable, given either the risk or the likelihood that it's going to be a much longer transition than anyone had thought.
Correct. Yeah. I mean, depending on how that funding and if there's potentially even a change in government during the life of this plan, then the multi-user ferry precinct might be back on the table. But at this stage, there's a bit of uncertainty.
Yeah. Having cancelled the order for the new boats, that'd be a big shift. Back again.
I can step through the key recommendations.
If you could go now to the key issues as you see them.
So from my section 42A report, there's 4 key recommended amendments. The first is some minor amendments to policies to add reference to the coastal marine area, like a Wharawhara stream and estuary, and so adding those to the precinct policies. There's also a recommendation to remove reference to heritage buildings, structures and areas because there are none in the vicinity of the multi-user ferry precinct, and to add specific reference to freight and passenger port networks and port precinct in the multi-user ferry precinct policy 3. The next key amendment is to Ports Precinct 01R2 to permit up to 10,000 metres squared of office activities in the IHPP. The third amendment is deletion of Ports Precinct 02R1, which permitted 500 metres squared of commercial activities in the multi-user ferry precinct. And the last amendment is to add a new permitted activity rule for Ports Precinct 01R7, which is the Inner Harbour Port Precinct, in response to the submission of Centreport, and this new rule permits alterations and additions that meet certain criteria in new buildings less than 100 metres squared and result in a building coverage of no more than 10% across the precinct. So as set out in my supplementary evidence, only Centreport raised any outstanding matters. The key remaining issues in contention as I see them are the rule framework for passenger port facilities and the redevelopment of the IHPP, primarily in relation to policy 4 of the IHPP.
Okay, thank you. Mr. Birch, do you want to take the lead?
In terms of um, you've clarified that given the uncertainty about the IREX project, you consider that provisions as set predated the consenting of the project anyway.
Yes.
They continue to be relevant.
Yes. Yeah.
And Centre Board obviously agree with that. That's their intention, is to have the same sort of flavour, just the way of getting there might be.
Yeah. Correct.
Other provisions with this, a lot of looking, staring at really intently to make sure that you get the right provision, just with the numberings. Just make it as a comment, I'm sure other people have the same thing, so just bear with me to make sure I get the right one when I'm talking.
Bits of benefits. Precinct 01 is the Inner Harbour Port Precinct, and Precinct 2 is the multi-user ferry. Yeah.
So in terms of B1, they rejected the Interport submission requesting additional wording to include adjacent commercial port area. And so that the third clause in that policy votes for that. It identifies land uses and activities. Commercial port.
Yes. Yeah. That's,
But it essentially already encapsulates what Centre.
yes. Yeah. So I don't consider there to be any changes necessary, as it's already captured in that clause.
Even agreed with Centre Board to delete clause 3A, prec 02 B4. However, that has not transferred through to your Appendix A, but in your rebuttal it had. I don't think it has either. Is that right?
So yes, that seems to be correct. I've recommended deletion of it in the Appendix A for ports precinct 02 P2. But yes, I haven't done it for the policy 4.
That's just a presentation glitch.
It is, yeah.
It is, yeah.
It's highlighted. Okay, things spelled right, but Kaiwhatawhata stream is just missing the other bit of the other.
Oh yeah.
Where's that?
So O2 P4, 3D. Oh, just got a spelling mistake.
Oh, yeah.
Stream. Just in relation to
While we're talking about picky typos and things, where you've inserted interface with the main remainder of the port zone, would it benefit by putting the in the front?
Which policy is
So
it?
that's Preco 1 P4 3D. Not a big point, but you might care to just put a circle around the language. So it's the insert that you put into,
Oh, this is my supplementary.
yeah, Prec 01 P4.
The one piece one.
I think it's in both actually.
Yes, yeah, adding the word "the" would read better.
Sorry, Commissioner, go for it.
just a question in terms of Eco 1 Rule 2. This is for the net area of lettable floor space. You can increase 1,000.
Yes.
Notified was 2,000. Could you just explain so I'm guessing that the reasoning was that the notified rule was unachievable.
Yes, yeah.
Currently
It currently exceeds that floor area.
exceeds it anyway,
Yes.
so hence your increased 2,000.
Yes, which then would provide approximately 2,000 meters squared of
2,000
additional.
new.
Yeah,
New.
2,000 new.
Unless they knock over some of what they've already got.
Yes.
And I think in your rebuttal, you've agreed with Preco 1 7, agreed to remove the notification clause.
Yes. Yes, that's correct.
And you believe that the Section 95 assessment can prevail.
Yep, correct.
In terms of Preco 1 P4, Centreport, I think that clauses 9 and 10 do not align with the otherwise enabling policy activities.
I think I've responded to it in my supplementary evidence. I believe the view of Centreport was that those clauses shouldn't relate to operational port activities. And my response was that that particular policy as it relates to the precinct would never not be applicable to, or would never be applicable to operational port activities, as they would be enabled through the policy and rule framework for the underlying port zone, which provides for operational port activities as a permitted activity. So those clauses, yeah, would never not be applicable, would never be applicable to operational port activities.
Go ahead.
In just picking up on that point, there's an issue in my mind about how Preco 1R4 is framed, where you've said existing passenger port facilities. You've accepted there might be room to make that clearer I wondered whether an easy way to do that might be to alter the description of the visions, the activity, be the mirror image of R7, but without the not. I would say construction of buildings and structures and alterations and additions to buildings and structures related to existing port facilities or operational port activities in the inner harbour port precinct. And then the difference between R1 and R7 would be that R7 has the permitted activity preconditions
Yes.
and R1 doesn't.
Yes, and that was one of the options in paragraph 18 of my supplementary.
So I think you're going down that, you're thinking down that track.
Yes.
With that, like that appeared to me to be the clearest way to, because I think the issue that Centreport are picking up on is that R1, R4 saying existing passenger port facilities doesn't appear to allow for extensions and additions and things they tweak here and there.
Yes, I think the intent of that rule framework, though, is to differentiate between existing passenger port facilities, which I determined to be Bluebridge and Inter-Islander, that they can continue to operate as they need to. So it's a safe and efficient operation of their activity. Whereas if in that multi-user ferry precinct, there's a new passenger port facility being constructed, that would then be a different rule framework.
And are you comfortable that if you did that, to make that absolutely clear, then that would deal to Centreport's problem? They may not think it deals to it, but you'll be comfortable with
I would be comfortable, yeah.
Sorry, Commissioner, you go.
Thank you. That was my last question.
I'll go now, please. Just by way of clarification, going back to 32A. Paragraph 43. Terminology, referring to the proposed NRP. Do you mean the operative NRP or the proposed plan change 1 to the NRP?
Great question. What was paragraph 43, was it?
Yep. Or 40, yeah, 43.
In that particular reference, it would be the operative.
Right. Next question I had was about your so it's important to clarify that the wharfs themselves are not within council's jurisdiction, but that the adjacent land is, and you inserted a reference, say commercial point includes land adjacent to. So the question I have for you is, what is the scope for that change? What submission has sought that change?
It's paragraph 43 still?
49. 49 and the relief recommended at 55.
I believe it relates to a submission from Centreport, which is referenced in paragraph 49.
Yeah, I know it says include reference to the wharfs, but you're referring to the land next to the wharfs. That was what and made me wonder whether this is a bridge too far.
I think it is also related to a recommendation that I made in the General Industrial Zone Section 42A report, which is set out in paragraph 50 of this 42A report, that Centreport sought that there be the recognition of the Miramar Burnham Wharf precinct, that there's that interrelationship recognised in the PDP, that the commercial port is also
So it's
within-
so it's consequential on your JIS recommendation.
correct, which then just provides that consistent recognition across the PDP chapters.
Right. Paragraph 52, talking about where spatially is Kiwi Rail designation KRH1?
I believe KRH1 covers the full extent of the rail corridor throughout Wellington City, but as it relates to the port zone, it covers all of the rail yard area surrounding the stadium, if you can picture that in your mind.
Yep. In the paragraph 53, you don't think it's necessary to amend the definition of rail activities. Is there any harm from doing it, from amending it?
I don't consider that there would be any harm. I think it probably relates back to the discussion you had with Mr. Jeffries this morning about then that overlap with the designation that Kiwi Rail would have, and whether there's a need to then specifically provide for that through the rule framework in the PDP in this chapter. So I think the extent to which Kiwi Rail would undertake rail activities is more appropriately provided for in that designation.
The discussion that at your paragraph 68 talk about Mr. Palmer's submission, you're noting we're talking about access, that the port has operational functional needs that may mean that access has to be restricted. I wondered, and therefore that it's your view that public access is more appropriately managed through provisions in the public access chapter. I wondered if the reverse is the case, that if it's the particular needs and the particular characteristics of the port that give rise to the need to restrict public access, whether it shouldn't be here rather than in the much more general provisions relating to access, public access across the entire CMA margin.
I think based on my understanding of the national planning standards, that the public access chapter would be appropriate in some respects, and I think there's a very specific policy on it's either for regionally significant infrastructure and or it specifically mentions the port, but at the same time the reverse is covered in the policies of the port zone, where it's worded that only allow activities not related to operational port activities to establish where it doesn't compromise the safe and efficient operation of the commercial port. So I think there is policies that address that kind of reverse point of view, that in terms of the access.
So maybe the answer to Mr. Palmer's submission is that is the, as you said, that PAP3 already covers it.
Yes, correct.
And two questions about your discussion of port zone policies. The first is about Port P4, where you Centre Port have sought to avoid revenue mitigate. You've said, well, that's not part of the style guide. And currently, it says manage. Isn't there a bigger issue that the port that the policy doesn't actually give any direction as to what's happening? It just says that something has to happen. Sort of manage to what effect, to what end result, and the same would be the case of avoid, remedy, or mitigate. How much mitigation? How much avoidance? How much? Like I'm putting myself in the shoes. Never been in this role of a consent planner, and saying, well, what are they supposed to make of this? It's sort of think about this. To which the answer is, well, yeah. And after you've thought about it, what are you going to do? What direction is that giving? And the answer, your answer may be, well, done, but that's there's no scope to change it. And,
Yeah,
which is a legitimate answer. It is what it is.
just rereading my response in paragraph 99 is that the word manage is widely, a similar policy is widely used across other special purpose zones in the PDP. I think it's just a consistent adverse effects policy that has been added in.
Like you and your colleagues might get the same question for each one. What's the end result of the management going to be?
I think this policy as well, though, probably provides that directive for the noise and light chapters, which is what that policy specifically references, the noise and light emission.
Like if there was scope, should it, like in a perfect world, and obviously we're not in a perfect world, should it say something like consistent with the objectives and policies of the noise and light chapters, if that's what you mean.
I'm not sure there is the scope for that, but I can,
Yeah, well,
I can look
that's right,
into that.
and that goes back to my previous point. Your ultimate answer be nice thought, but no scope.
Yes.
And
Just to follow up on that.
go for it.
But I could, at the same point with objective 2 could be made as well. Adverse effects from activities and development within the port zone are managed effectively.
It is that's very
We're
broad.
managing the noise effects quite well, I think. You know, one end.
So, I think you better add that to your.
Yeah, I mean, Centre Port thought that that objective was retained as notified and there was no other submissions on that.
Yes, I can understand why they might have been quite happy with that objective. Paragraph 100. This is the point we discussed with Mr. Jeffries, where he removed an objective in the airport zone because it was purporting to manage activities outside the airport zone. And here, so this whole policy is about seeking to establish adjacent to the port zone, i.e. outside the zone. So is there a problem with the policy? And again, we might go back to, yes, there is, but there's no scope to change it. But let's talk about the merits first.
Yeah, I agree. It probably shouldn't say adjacent to the port zone. It should refer to activities, sensitive activities seeking to establish within the port zone. I'll have to go back and check if there is any scope to make that amendment.
The addition you've recommended in 112 about, yes, I can understand the second point, the interface with the remainder of the port zone, but I thought it was really intriguing, sort of talking about particularly where it's adjacent to the CMA. Is there any part of that precinct that isn't adjacent to the CMA?
I mean, there's parts of the precincts that are adjacent to the waterfront zone, but
it's sort of like contradictory, that like a port zone is by necessity next to the water. It's certainly near the water, which is what adjacent means. So is that adding anything? Because if the whole precinct is adjacent to the CMA, so that's P10.
I think it adds value that you respond to the site context, which includes any activities occurring within the coastal marine area. The view of Centreport was that it was a relevant matter, and I agreed with their reasoning.
The My last question is, second last question is about the ordering of the rules and this, and in particular the precinct rules. Like I understand the rationale for you've got land use activities and then buildings and structures. But would it be more user friendly if all of the port zone rules were together with that distinction, then all of the Preco 1 rules were together with that distinction, and then all the Preco 2 rules? Because I ended up going backwards and forwards between these things for quite a while, buttering as I did.
I agree. The fact that it's also precinct 01 and precinct 02 makes it very confusing.
And
But
it's here.
The way it's set out is consistent with the national planning standards and
I thought you were going to say that.
and how other precincts in the PDP are. So the MRZ chapter and its precincts are set out the same way. It is confusing, I agree, but that is the consistent approach.
And promised the last is the 167, your logic, fighting for small scale activity tied to a 10% precinct wide building coverage threshold. Would it be more understandable if it was a GFA threshold rather than a percentage of the building coverage? That up to a maximum of X meters across the X square meters across the precinct.
Yeah, it could be.
Like that, as I say, I'm not weird to it. I just read that and thought
The rule 7 for the IHPP has with the gross floor area of the building is 100 meters squared or less, and
but your point is that you don't want them a proliferation of 100 meter permitted activities, so there has to be an overall cap. And I'm saying, well, should that overall cap be in square meters rather than a percentage of the precinct?
yeah, that's something I could consider, that option.
Commissioner Schofield.
Some of my questions were picked by the chair. Just a couple of points. The multi-user ferry precinct, you're recommending deleting any sort of provision as a permitted activity commercial facilities. And we've just come off the back, as you heard, of the airport zone, where in my mind there's a corollary in terms of the airport terminal is like a multi-user airport terminal. And as you know, that it does have quite a component of commercial and retail activities inside it. So I could imagine if a multi-user ferry terminal was ever to be developed, that it would have a similar component. So I'm just wondering why in principle at that level, notwithstanding the sort of confused submission from Centreport on this matter, I was a bit confused by that. Why not any provision for commercial and retail activities?
So in my view, it goes back to the long-term vision and purpose of the precincts, and that the multi-user ferry precinct is primarily for that passenger port aspect. And within the definition of passenger port facilities, there is an allowance for ancillary retail and commercial, including food, and just open the definition. So yeah, it includes refreshment facilities and food and beverage outlets and ancillary retail. And I think whereas the purpose and long-term vision of the IHPP is to provide for that more mixed-use waterfront environment, and that's where I consider that commercial activities would be more appropriate to locate in that precinct.
Right.
So deletion of that permitted activity rule is consistent with the relief sought by Centreport, and it would still enable commercial activities as a discretionary activity through the rule framework.
Okay. And that sort of relates talking about the Inner Harbour Port Precinct too, because that talks about that one of the objectives is to transition in a coordinated and integrated manner to a mixed-use waterfront environment. So I wasn't quite certain why you opposed Centreport's suggestion of adding in commercial port zone into clause 3 of precinct 01 P1, because while at the moment it is part of the commercial port area, clearly, over time that will transition to not being that. So I would have thought some reference to the proximity to a working port and the compatibility with that would be a useful point to
Which policy was that? Sorry.
This is Inner Harbour Port Precinct P1. It's clause 3, and they were seeking to add in and the adjacent commercial port area, notwithstanding some debate around the terminology, but, and you're saying, well, it's all part of the commercial port area anyway. But I'm thinking that as it's a transition area and as it's developed, it is right next door to a very busy working port.
I think I responded to it in my supplementary. If I just find what I did there. But I think the commercial port area is defined by the NRP. So even if the commercial port were to transition out of the IHPP, the definition of commercial port area would still remain that's the same in the NRP.
Mm.
And I think
Can you remind us what that definition is?
it hopefully is set out somewhere in my 42A, but the NRP refers to a set of maps which spatially identifies the commercial port. I'll just have a look if I can find that definition.
That may be where I asked you about whether it was the operative.
That's the waterside part of the port.
Yes.
But I'm also thinking of it in an integrated way in terms of the land side and the water side. So you'd still have this area of transition to a mixed use zone right next to a very active working port, both land side and seaside. I mean, we might hear more from this on Thursday, but I was just sort of thinking that in terms of developing an integrated sort of mixed use zone really over time, its relationship with its neighbour is an important matter.
I mean, it's a matter I can reconsider.
I want time to think about it.
Looking through my notes, I found one other question relates to your supplementary, and that's at paragraph 20. You're saying discussion is about this is what Mr. Schofield's identified. Site context includes the remainder of the port zone and looking for an exception, and you're saying operational port activities are permitted throughout the port zone under R1 and R5. So P4 is an irrelevant consideration for operational port activities. And I was thinking, well, wouldn't, in terms of the provisions of the rules, R1 wouldn't apply, would it? That because you're in the precinct and therefore if it's not in Rec R1 or R2, you're into Rec 01 R3, which is all other activities that are discretionary.
In terms of the activity status for operational port activities.
Yes. Within the precinct.
My understanding is that the underlying zone rules would enable the operational port activities as a permitted activity.
But the problem is that, like, the provisions say
Or are you saying
where there's a conflict, the precinct rules apply. Precinct rules say that anything that's not a commercial activity or an office activity is another activity and it's discretionary. So don't you have a problem?
so the all other activities rule should expressly exclude operational port activities to address that?
Yes, that would be one way to take it, but like, well, for a start, am I reading it right that there is a problem because of the that definition of all other activities or that rule. Like I think that would be the solution if there's a problem, but is there a problem?
I mean, the all other activities rule is worded as the activity is not otherwise provided for as a permitted activity.
Well,
For absolute clarity, it could say excluding operational port activities. I can see if there is the scope to make that amendment.
yes. So what you're saying is that the way it was intended to be read was if it's not otherwise provided for as permitted or restricted discretionary, either in the permitted activity rules of precinct or in the wider port zone.
Yes,
Like
reading between the lines, that's where you would get to, I would imagine.
Just picking up on that point, because the explanation in the introduction, the second to last paragraph in the introduction to the inner harbour precinct talks about the land use activity rules for the port zone apply to the inner harbour. But I still see the chair's point in that you've got this other catch-all thing. Not very clear, that relationship.
So any more people? Oh, looks like we've got 3/4 of an hour to talk about the quarry. Again, Commissioner Schofield is sitting this one out. Next, and we'll go from there. So we have what appears to be quite a discrete set of issues in contention, but would you care to take us through your report and your supplementary? See where are we? Where are the short straws that we're down to?
Just give me 1 second to pull up the quarry chapters. Okay, so for the quarry zone, there were no submissions seeking any significant amendments to the quarry provisions themselves, and there were no amendments recommended in my section 42A report other than a small zoning change to part section 16 Harbour District from natural open space zone to quarry zone. The only remaining issue in contention is the zoning of Hotokiwi Quarry's owned land. I continue to recommend that the land sought to be retained as general rural zone or natural open space zone, while Ms. Whitney, on behalf of Hotokiwi, seeks rezoning. Happy to take any questions, but it's just that one outstanding matter.
Maybe we should go first to the essentially legal question, which is what is the existing use certificate actually mean, and what relevance is it? Like that's the underlying thing that I'm interested in. But the first thing you can ask me is that how is it that there are two of them? That one that you produced and one that Ms. Whitney's produced, and what's the relationship between them? which was first and which was second? And does the second supersede the first? And where does it say that?
So yes, the existing use certificate that Ms. Whitney provided in her evidence is an earlier version of the certificate. The one appended to my evidence is the revised version, a couple of months later. I am not sure why they exist or which version is. I would assume the latter version is the more up-to-date, relevant certificate to look at.
Like the thing that's exercising me is that the RMA says that an existing use certificate is a resource consent. So you've now got two resource consents for essentially the same activity. So that's why I framed the question sort of, is there anything that actually says that the second one supersedes the first, or do they just sit side by side and both apply?
It's probably a matter more for our resource consents team to address. I wasn't part of that process as to when or why the revised one was sent out.
Well, I think it's partly a factual question and partly a legal question.
It might be best for Ms.
Well, and so if there is an answer on the consent files, then well and good, we see that. And if that's not, can Mr. Whittington please address, as part of the council reply, how those two documents relate to each other? And as I say, do they sit side by side? Does the later one supersede the earlier? Given, as I say, that they have the status of a resource consent. And the next question is, have you researched the situation underlying this? Because I read the page 3, which refers to a decision from the Town and Country Planning Appeal Board, which is the precursor of the Environment Court, which confirms an interesting word in this context, is permitted to carry on quarrying activities as a conditional use in the Wellington City. Now, it's a long time since I read or worked with the Town and Country Planning Act, but my recollection is that a conditional use is a controlled activity, or was a controlled activity. So is that saying that the quarry has a existing resource consent, and that's what this certificate is confirming? Or is it saying that it's an existing use for the purposes of Section 10 because it was established lawfully without need for a resource consent, i.e. as a permitted activity? Like that reference would suggest it's the former, because
My position in the Section 42A and my supplementary is that the matter of if or how or to what extent the existing use rights apply is not a matter for me to determine as part of this process. I think it's a separate resource consent matter and not relevant to the PDP. I've just merely provided that existing use certificate that is the most up-to-date revised version that the council has.
Yeah, and I think it's valuable that you've put before us the second one, even though it has thrown up all these curveballs about what its status is. But going to I understand that that's your position, but can I ask you nonetheless to go back through or dispatch someone, one or other, to get to the bottom of what exactly that, like ideally give us a copy of that 9 February 1977 decision so we can see what it says.
It might be very difficult to track down, but we'll try and track it down.
Back in the day, MFE used to have a library of all unreported Town and Country Appeal Board decisions. But it may be that they've long since turfed it. So I'll ask you, because the reason I'm following this up is that while you're right, and of course, in theory, that a resource consent to undertake an activity does not automatically translate into a zone provision in a plan, quarries are a bit different, because once the quarrier rolls in, essentially, unless and until they roll out again, having rehabilitated the site, the land's effectively useless for any other activity. So that would be the counter proposition I would put to you, that yes, in theory, but maybe quarries are the exception.
Might be a question for Mr. Whittington to best address.
And the next question, an issue of fact, also arising out of the qualification in the existing use to it. It says exclude escarpment faces that might have a visual impact when viewed from the direction of Wellington Harbour. How much of the two sections that are an issue would be within that exception? How where's the ridge line in relation on the harbour side going on those two sections? Because it's pretty obvious that the rural one goes all the way down to the motorway. So obviously a chunk of it, some greater or lesser extent, is going to be visible from the harbour. So, but how much? Is it all of it?
So in relation to that specific statement and the existing use certificate, again, I would say it's best addressed by the consenting and compliance team. But in terms of the visibility of that ridgeline, yes.
I think it's a factual question. Like, as I say, by all means.
So yes, that rural site is, in my view, visible from the harbour.
But what you can't tell from plans is whether the ridge line is above the top of so the whole site is visible, or whether it's some of it pokes over the top and wouldn't be visible. So, like, that's the factual question I'd appreciate you getting some more information about.
I mean, having visited the site, I would say the majority of that ridgeline, if any quarrying activities were to occur on that rural zone site, it would be visible from the harbour just because of the topography of where the existing quarrying has kind of cut that. Yeah, my view is that it would be visible.
And the other side around the sediment pond, is that up on the top, so it wouldn't be visible?
If they were dependent on where or what quarrying activities were occurring, if it was down by the sediment pond, no, that's hidden behind the hill, the topography, and you wouldn't be able to see it from the harbour. But if they were right on top of the ridge near Hutt Road, then yes, it could be visible.
So, like, I appreciate you going from your impression from a site visit. I think we need to know where those where the ridge lines are marked on. Can you supply a plan, like an overlay that shows where the ridge lines are relative to the legal boundaries?
I can do that.
Oh, that's an overlong introduction. I should pass over to Mr. McMahon. An introduction about existing use. Like, he of course is too young to remember the Town and Country Planning Act.
If only, Mr. Chairman.
To clarification on that ridgetop overlay.
Yeah.
So in the ODP and the PDP, there's no ridgetop overlay that
No,
applies.
like,
But the topography map that.
yeah.
Okay.
I'm interested for the purposes of the existing use certificate, what would be visible from the harbour? And I use the ridgeline as a premise that even right on top of the ridgeline would still be visible, but back even depending on profile behind first ridgeline, it's what's visible from the harbour that I'm interested in. That's knowing where the contours are as a means to an end.
Okay. Thank you for your presentation. Clearly, I'm going to focus on the 2 parcels of land or 3 parcels of land that have been requested to be included within the Quarry Zone by Horokiwi. And just for the record, there are 3 parcels, but essentially they are 2 distinct sites, aren't they?
Yes.
Yes. And one site's zone open space, site to the southeast, and the site to the west is zoned rural. Correct.
Is it west or south? Get my directions.
One to the left and one to the right.
Yeah,
One to the
let's
left.
go with that.
Yes. Let's call them site 1, which is the
Open space.
open space zone, and site 2 being the rural zone.
Yeah, and noting that there's 2 lots that form
Yes.
part of that.
Yeah, 16 and 18, I think, and 7. So 16 is site 1 and 17 and 18 site 2, I think.
Yeah, I think that's correct.
Okay. I don't want to just touch on the existing use rights matter at all, other than to ask you whether, notwithstanding the different dates and whether they supplement each other or one replaces the other, is there any substantive difference between the 2 certificates in terms of what they pertain to authorise?
As far as I'm aware, the key difference is that the revised certificate identifies the scope of activities occurring on the site at the date of the certificate. So that's
the only difference.
That's set out in section 10 of my supplementary, and as far as I'm aware, that is
Okay.
the only difference.
Okay. My starting point is your paragraph 58 of your section 42 on page 14.
Yes.
And particularly where you say whether or not the existing use certificate adequately covers the full scope of the quarry's existing use right. It's not a matter determined as part of this process. Rather, it's a matter for the council's consenting team. The more pertinent question, in my view, is whether it's appropriate to zone so as to enable the increase in the scale and intensity of the quarrying activity, and if so, on what basis. And that's the focus of my questions to you, because I think that is the right question in the Section 32 sense. It's what's the most appropriate zoning of this land to give effect to the policies and objectives which are assumed to give effect to the higher order documents. So with that said, I was a little bit intrigued that paragraph 59 through to 62, you did then go on and focus on the existing use certificate. And I wasn't expecting that, but you have done that.
I think it's more of a just historical background to activities occurring on that site,
Yes,
irrespective of existing use rights. It's
Yes.
just the history.
yes. But you stand by your point that it's not a basis either way to
No, you're correct.
be determinative of the appropriate zoning.
Correct.
Okay. Your second sort of limb of your discussion is that if the zonings are unchanged, and this is particularly in relation to the rural zone, there is a consenting pathway in place. And I need to understand that more particularly. You go on to say that it would be, well, what is the consenting pathway under the rural zone absence the overlays?
So in the rural zone, the discretionary, I believe.
You're clear, you're obviously reaching. Can we leave it on the basis that you're giving us your recollection and if having checked it down the track, it's not right, you'll come back and tell us. But if you don't tell us, we'll assume that what you're saying now, you've satisfied yourself is right. Don't worry about needing to thumb through a whole lot of rural zone rules that are the subject of the hearing. It's going to be next month. But just give us your recollection.
My question is, what is the activity status of quarrying in the rural zone absence any overlay?
I'm fairly certain it's discretionary.
Okay. And in the open space zone for the for site 1?
Off the top of my head, there's no specific rule for quarrying activities, so I assume there would be a catch-all, all other activities discretionary rule.
That brings up another matter I meant to acknowledge, and that is under the operative plan, there isn't a quarry zone, is there?
Correct.
So this is a new construct
Correct.
derived from the national planning standards, presumably.
Yes.
Yes. So quarrying was established on these sites under a mix of rural zoning, conservation zoning, open space zoning.
Correct.
Yes. Through resource consents and possibly existing use right certificates.
Yes.
Okay.
It could have been pre any zone, any plan,
Yes.
given how long it's been.
Okay. And then thirdly, particularly in relation to site 2, you say that even if the zoning was changed from rural to quarry, you still need to apply the overlays, the SLAs, the coastal environment, and the SNAs. Sorry, not SLAs, SALs.
SALs and
Yes.
SNAs, yes.
Yes. And that, and I'm reading from your paragraph 65 here, that it makes no material difference whether the site is GRUS or quartz because the activity would always default to DA under the notified plan. So the DA status absence the overlays doesn't go any further than DA when the overlays are applied?
Yes, so with or without considering the overlays in the GRUS chapter, it would be discretionary. And when you consider the NFL chapter, it would also be discretionary.
Okay. Right. Well, I'll invite you to come back and just confirm your understandings of the activity status under both the.
I have checked it, and that is correct.
And it applies to the open space zone also.
Open space.
The default.
I can come back to you on that.
The default.
It would be a catch-all all
yeah.
other activities.
Okay. Thank you. Okay. that's the sort of so what question as to what happens if you don't zone or zone. So the one I now want to move on to is what guidance do we get from the district plan at the higher level, both at the strategic objectives and at the objectives and policies level? And you've referenced the new strategic objective SCA 07 that was recommended by Mr. Cutchin.
Correct. Yes.
And that's now been, I think that's now part of the officially part of the recommendations of the panel. And then
Yes, and we may or may not know whether they're accepted on the 14th of.
yes, but for the time being, that was one of the few areas where the panel moved away from the proposed plan and added in some new provisions to recognise the benefits of quarrying activity to the city. I've read the evidence. Is it Mr. Baker?
Yes.
Yes, Mr. Baker, Ross Baker and Ms. Whitney. They make a big play of the difficulty of establishing new quarries or even extending quarries. And that's a function of the topography of the city and where the resource is. And their thesis, if you like, is that if you are going to give effect to this new strategic objective, then the best way of doing that is by zoning extensions to the existing Horokiwi quarry, both to the left and the right, sites 1 and 2. And whereas you seem to be saying, well, another way of giving effect to this is to rely on the other zones to provide a consenting pathway. And I accept that if you're right, both sites would have a DA status regardless of whether the rezoning's retained or changed. But wouldn't it be more honest to recognise that that these sites are potentially suitable for quarrying and what is a limited land availability for that activity? And if quarrying is going to occur, that these are sites where it's possibly potentially more suitable than other sites within the city. In other words, isn't a rezoning a more effective and efficient way of giving effect to the strategic objectives than relying on non-specific zones that may or may not have a consenting pathway?
It may be. I think though the rural zone policies do recognise that, in particular, if there's a change of use on existing quarry sites. And I think, in my view, what could be reasonably expected for the quarry zone and where quarrying activities would occur is what the recommended extent of the QOS is.
Yes.
Can you repeat that? Sorry.
Can I repeat that?
You were talking about the rural zone policies recognising.
Yeah, so the rural zone policy 5 is quarrying and mining, relates to quarrying and mining. And it says that new quarrying activities and changes of use of existing quarry sites in the general rural zone. And I think, in my view, that's trying not to link it back to the existing use rights certificate, but it's that change of use on existing quarry sites that particular wording of the rural policy 5 is what, to my mind, makes it more appropriate to retain that site as general rural zone.
Okay, I don't have that policy in front of me and I wasn't on the rural ones, but just what's the operative word in that policy? What's the directive word?
Require.
Require.
Is that correct? I'm correct in that the rural zone 42A is being released this week.
Okay, so can you just read the policy in its entirety?
It's got 10 clauses to it.
Yes.
The entirety?
Well, the relevant clauses with the chapeau.
What is it requiring?
The title is Quarrying and Mining Site Rehabilitation.
Yes.
And it reads, require any new mining or quarrying activities and changes of use on existing quarry or mining sites in the general rural zone to demonstrate through a detailed management plan how the site will be rehabilitated, having particular regard to, and it lists 10 matters.
Yes, and are there any particular ones that you would draw to our attention?
Rehabilitation methodology, intended end use, location gradient of excavation, the surrounding landform, consultation undertaken with mana whenua, adverse effects associated with rehabilitation, and vegetation cover.
How does that differ in any meaningful way from the rehabilitation and management plan policies in the Quarry Zone? Because I've noticed that they have a similar theme, if you like.
They do, but I think my observation would be that the provisions for the Kiwi Point precinct are much more prescriptive in terms of rehabilitation and management plans in buffer areas, etc., that were established via Plan Change 25 and 63 as well. But the Kiwi Point precinct quarry has much more detailed provisions, and my concern is that there isn't that same level of discretion for council to consider the same range of effects for what I would consider to be a change of use of an existing quarry or an expansion of an existing quarry. Whereas I think the GRUS provisions kind of provide for that more detailed level of discretion for council to consider.
The activity status for quarrying in the quartz zone for Haruku would be controlled activity subject to meeting the relevant performance standards, and if they didn't, they'd default to either restricted discretionary or fully discretionary, presumably. Discretionary, I think.
Yes, yeah, discretionary.
Yes. Okay. So one of the questions I always ask as a commissioner when I'm looking at a rezoning, whether it's land development from rural to some form of residential, or in this case, rural to a quarry zone, is there any fundamental impediment to the rezoning occurring such that provisions in the new zone can't adequately manage them or provide a framework for the management? Have you addressed that in terms of the ability of the court zone to actually effectively manage development on the extension into sites 1 and 2?
I think I've just considered that level of discretion of or matters of control for council to consider in that clause R3 are quite limited compared to if it was a full discretionary activity in the rural zone. And I guess having spoken to colleagues in the parks and open space team in relation to that natural open space site, and colleagues in the resource consent team, that they concur that the most appropriate zone would be the retaining as natural open space and retaining as general rural zone.
Would your answer be different if there were provisions in the Kiwi quarry that replicated the provisions in the Kiwi Point precinct?
Yeah, I think that would change my position.
Okay.
But there is limited scope to do so.
Well, why do you say that? I mean, if the scope is defined from rural to quarry, presumably on that spectrum, if the quarry component had some restrictions on it, such as those similar to the Kiwi Point precinct, wouldn't they be in scope of the submission?
Yeah, they could be. It may come down to whether the submissions received on that particular Rule 3 of the Quarry chapter, whether it was retainers notified.
Well, yeah, I acknowledge what you're saying. There's no specific relief sought, but a quarry zone without restrictions versus a quarry zone with restrictions surely is within scope.
Yes.
Okay. Is that something that you think is worth pursuing with Ms. Whitney?
It could be, yeah.
Okay. Okay, I'll park that. One of the other things I should have it somewhere, you say, oh yes, in paragraph 64 of your 42A, page 16. You say it's important to recognise that the purpose of the courts is primarily to facilitate a business as usual approach for the continued use and operation of Wellington's large scale quarries. That wasn't my reading of the purpose of the quarry zone. Can you point to provisions within that zone where it says that? Like the business as usual component.
Yeah, it was the first sentence of the introduction to the quarry zone. The purpose of the quarry zone is to enable the continued use and operation of Wellington's large-scale quarries.
There's not a spatial component to that, though, is there? I mean, if that's read post decisions on the plan, and the two large-scale quarries are zoned, and if the Horikiwi one includes the two areas, then the purpose of the quarry zone will apply to those extended areas, won't it?
It would, yes.
Yes.
So then that second sentence where it provides for quarrying activities where they operate as the primary land use on the site. If you're getting site specific, my view is that quarrying activities are not the primary land use
Currently,
but
for the planned purpose of the zone, they could be.
They could be, yes.
Yes. Okay. I mean, I'm intentionally taking a devil's advocate approach here. And a lot of these questions will need to be considered by Ms. Whitney and Mr. Baker.
Yeah, and we have a few putting the alternative approach for them.
Yeah.
So I wouldn't want you to feel that put
No.
upon.
Yeah,
The last thing we want to do is leave the hearing not having asked all the pertinent questions.
I think Ms. Whitney and I have both in our evidence very clearly set out our thoughts on the matter. And it's just I guess in your hands to balance and weigh it up.
Now, let me just check the rest of my notes because I went through your 42 and rebuttal quite carefully. Oh yes, sorry. Your 42A does recommend a slight change in that the area around the sediment pond is proposed to be rezoned for quarry purposes. That raises an issue of not following cadastral or legal boundaries for such a zone. What's your response to that criticism?
My response would be that I believe we have made similar amendments to other zones in the PDP and that this would not be a unique amendment.
Okay. Yeah, we're talking about site 1 here.
Yes.
Yes. There's also been mention of an overburden area,
Yes.
which goes beyond that sediment pond area, I presume.
Correct, yes.
That was an alternative put forward by Ms. Whitney.
Yes, so that was newly introduced in her evidence and
Yes.
that relief wasn't sought in her submission or their
No,
submission.
but it could be within the spectrum of scope, presumably. In the same way that a restricted quarry zone with a precinct might be.
Yes.
Yeah. Effectively, or essentially, what's your concern with adding that overburden area, putting aside that it's not, well, what is your concern with adding that to the extended zone?
So my supplementary, I've set out that an approved consent, in my view, is not sufficient basis to justify rezoning.
What paragraph is that?
That's at paragraph 13, page 2.
Yeah.
So I've outlined that consent was granted in 2015 and has yet to be given effect to.
Has that consent lapsed?
It has not lapsed, I believe, in July of last year. I believe it's set out in my.
Yes, there was a section 125 extension.
Correct.
Yes.
But as far as I'm aware, it is yet to be given effect to still.
Yes. So you're saying that an unimplemented consent is not a basis for rezoning?
That's my view, yes.
Would your view have been different if the consent had been commenced for that overburden area?
If there was active quarrying activities occurring and that had been given effect
Yep.
to, then I would consider.
Would you consider that the suitability of that overburden area for quarrying has been considered in terms of the consent that was granted?
Yes.
Yes. And what's changed to change that suitability for quarrying? Anything?
Not necessarily. I just think that the fact it hasn't been given effect to in almost a decade puts into question whether it, if and when it will be used for quarrying activity.
Or have the values associated with that site, have the adjoining land uses changed significantly in that decade that would question the suitability of that site for a component of quarrying?
Potentially the residential activities in the adjacent, I'm not sure what street it is, but potentially.
That's so Newlands has expanded out there in the interim.
Would you be able to capture that zoning change or residential activity extension graphically?
I can note that down and reply to that.
That would be good. Okay, so I guess where that leaves me is two explorations that might be required. One is whether there's some ability to extend the recommended zoning area from beyond the sediment pond area to include the overburden area. And secondly, whether there's a possibility of adding a precinct type set of rules into the Horokiwi, similar to Kiwi Point, to provide for some of the effects management, particularly around rehabilitation that you talked about. And that's all from me.
One question only from me, and that goes to your reasoning. At your section 341, talking about objectives, quas 02. It's a request for practicability carve out, and you've given us a series of reasons for your position. I wondered if there was a simpler reason, and that was the objective talks about appropriate management, and appropriateness could easily consider practicability as it is.
That would be another reason, yes, I agree.
I won't ask Commissioner Schofield this, tempt him into asking any questions. Commissioner Bertram.
One minor, I think that it's been well canvassed, so I've just got a minor question. Just in paragraph 83 of your 42, you talk about quarrying activities as being a less hazard sensitive activity. You've got it in inverted commas. Is that defined, or is it?
That is a defined term.
And
yes.
Yeah. And the part that you've recommended to be that follow the boundary of the SNA. How that the purple SNA that you've got in your figure 5,
yes.
And then you go down further to the bit that you have agreed to rezone. Does that correspond with the boundary?
That is the intent, but the plan prepared in my recommendation 77 might need to be, might not be accurate.
Yeah, I just thought it was a little bit different, but it's hard to jump
Yes.
between the two.
Yes.
I just,
The
Yeah.
intent is that it would
the
align
intent would be to match with the
SNA.
Yeah.
Yes.
Certainly the shape of that area in figure 5 and the figure on the next page seems to match.
yeah, it is hard to.
It might just be the scale of
Yeah,
the different
exactly.
images.
That was just that's what I wanted
Yes.
to confirm.
The intent is that SNA.
That was all for me.
Uh, I have one further question. I asked you about the policy framework in the rural zone and you've for quarrying and you've given, if you could reproduce that also, but I'm guessing that there's not a similar policy framework in the natural open space zone.
Can I just, before you go there, Commissioner, can you just repeat that? You said first one, so I got a clear note.
Sure. I've asked Hannah to replicate the relevant policy on mining and quarrying from the rural zone.
Yep.
And provide any commentary on that. And then I've asked her, I've said presumably there's not a similar policy in the natural open space zone.
No.
And the codicil to that last question is, what is the policy direction in the natural open space zone as it relates to activities such as quarrying? Because whilst I guess the quid pro quo of that question is, whilst you say there might be a consenting pathway for DA in both zones, the potential difference might be the policy direction.
Notwithstanding there may or may not be existing use rights as well.
Yes, notwithstanding existing use rights, yes. So I'd like to understand what the flavour of that policy direction in the NOS said is.
I can look at that for my better reply.
Thank you. Through you, Mr. Chairman, certainly I would benefit, I'm sure the panel would, for some site visits, and presumably we can take that up with the submitter tomorrow.
Yes, I think given that Mr. Halliday won't be in a position to take us to the development area, we have that opportunity if Mr. Baker is available to host us. I think the plan would be that we'd wish to take our reporting officer with us if we're going to be escorted by a representative of Kiwi Quarries. We'll leave Commissioner Schofield behind. And so we'll talk to Mr. Baker about that when he appears. I'm looking at this map. I think in terms of the question about, well, has the residential environment changed? Is it Bendigo Grove? I'm looking on your figure 5. When was that consented or zoned, and when was it actually built relative to the grant of that consent would be the interesting questions.
I think there's two issues here. When was it zoned?
Yes.
And then when was it consented?
Yes.
Yes.
I can look into those questions.
So be helpful. And we'll ask Ms. Whitney to, when she appears, whether Harakiwi opposed those. Any more people? Well, at 2 minutes past 1, we'll call time for the day. Back at 9 a.m. to talk about development areas. 9 a.m. tomorrow. Thank you very much.
Thank you.
We'll adjourn the hearing until 9 a.m. tomorrow, 21 February.